May I please ask participants to take their seats? We'll be starting in 2 minutes. Very good morning. I would like to welcome everyone to the second week of our HDIM. I can see that everyone is smiling, full of energy. It is my great pleasure to welcome you to the working session 10, Rule of Law. We're going to discuss issues such as independence of the judiciary, democratic lawmaking, ensuring equal enjoyment of rights and equal participation in political and public life. My name is Marcin Walecki. I'm head of the Democratization Department. It's my great pleasure to moderate this session. The session will look at a number of issues, but what we are particularly looking at is the issue of independence of judiciary, as it is essential to maintaining public trust in democratic institutions and to the credibility of the justice system. Participating states have declared that ability of judges to adjudicate free from interference is essential in safeguarding human rights. Participating states have also committed themselves to ensuring that judicial independence is guaranteed through law and respected in practice. We're also going to look at another element of rule of law, which is the issue of lawmaking, democratic lawmaking. Laws not only need to comply with human rights and rule of law standards, they also must effectively tackle increasing complex challenges. And participating states have committed themselves to adopting legislation as a result of an open process reflecting the will of the people and with maximum transparency and broad participation. There are going to be a number of important issues which we will discuss during this session, but please allow me just to remind ourselves how we're going to structure the next 3 hours. So, as always, the first 15 minutes will be dedicated to some technical remarks, to the remarks by our distinguished introducer, who I will introduce in a second. Then we will follow with a discussion, and I am reserving approximately 2 hours and 50 minutes for the interventions from the floor. During the last 15 minutes, delegations of OSCE participating states will have possibility to exercise their right to reply. The list is closed. We already have 50 participants signed on the list. We will also maintain a reserve list just in case there are slots available. As always, I would like to remind participants that HDIM plenary hall is designed in a way that it's clearly indicated on signs who should be taking the floor on whose behalf. Live streaming on 2019 HDIM is available. Filming with cameras and video cameras is only permitted by accredited journalists and only during the plenary sessions. No other audiovisual recordings should be undertaken without explicit permission of individuals being recorded. Let me now introduce our distinguished speaker for the session. Ms. Nino Lomaira is a public defender of Georgia. She was nominated to this function in December 2017. She's a very distinguished activist, has a long record with organizations such as ISFET, European Network of Election Monitoring Organizations, Georgian Young Lawyers Association. She developed extensive expertise in the field of rule of law, election law, She's regularly teaching courses on democracy and rule of law. She was awarded the title of the Human Rights Activist of 2014, and in 2019, she was named the Woman Leader of the Year in Georgian government. It is my great pleasure to pass the floor to our introducer. Madam.
Introduction. This is my honor and pleasure to be here to introduce today's session that deals with the rule of law, and in the framework of this session we will also discuss independence of judiciary, democratic lawmaking, and the equal participation in political and public rights. Let me start with independence of judiciary for a number of reasons. First of all, because independence of judiciary is a crucial element for rule of law. Independence of judiciary is instrumental and essential for ensuring protection of all human rights, and independence of judiciary itself represents human rights. Right now, independence of judiciary is number one issue in Georgia and the priority of Public Defender's Office. We had a really unprecedented and very interesting cooperation on this matter with OSCE ODIHR this year, and I would like also to share this experience with you, and I hope that you will find this cooperation and experience helpful in your context as well. Let me say that threat to judiciary may have various forms. In the past, the main criticism toward judiciary in Georgia, for instance, was lack of external independence and direct interference in the work of the individual judges by political power. But situation right now has slightly changed in Georgia, and the main challenge for independence in Georgia right now is lack of internal independence, which is a relatively new phenomena for Georgia. The case is that public defenders, civil society organizations, political parties are saying that there is some influential members, influential judges in the justice system which have majority in the High Council of Justice, which is the managing body of the justice system, and they are controlling the important processes in the justice system. For instance, they are making decisions regarding the appointment, promotion, disciplinary proceedings against the judges. This is the problem, and right now there is very important processes going on in Georgia. For instance, we have to appoint 20 members in the Supreme Court out of 28 members. This is 2/3 of the total number of judges in the Supreme Court. And this is the first time in the history of Georgia when all of them will be elected for lifetime. When the election process and the appointment process started, we have realized that there was no proper regulations guaranteed by the Georgian legislation, and the due process was not guaranteed by the law. So the parliament decided to draft the law regulating the appointment process of Supreme Court judges. And we have criticized the draft law, and afterwards a good idea came into our mind, and we decided to ask OSCE ODIHR to provide opinion about the draft law, and they have reacted quite in a very short period of time, and really high quality opinion was provided to the draft law about the appointment process, and which evaluated the standards, which evaluated the draft law in compliance with international standards and obligations undertaken by the state before the OSCE ODIHR. And this opinion was extremely helpful for us in communication with the parliament, because I have addressed the Parliament of Georgia, and my arguments during the plenary sessions was based on the opinion drafted by the OSCE ODIHR and the relevant recommendations. And it really had positive impact over the process. Some of the recommendation was taken into consideration, and therefore the final draft was improved. And after the law was adopted, we have once again referred to the OSCE ODIHR and requested to monitor the actual appointment process of judges. And right now, the monitoring mission is in Georgia. They have produced the first preliminary report about the process, and we think that this monitoring mission is playing very, very important role in the appointment process, in the accountability and the transparency of this process. I'm talking so much about the appointment process of judges because fairness and transparency of appointment of judges is crucial element for the independence of judiciary, and therefore represents the element of the right of fair trial. I would like also to provide you information about recent case law of the European Court of Human Rights, which developed strong international standards towards appointment of judges. Specifically, the court said that the right of fair trial of the applicant was violated as the judge who delivered decision against him in criminal case had not been appointed according to the due process. And this is really very important case, and I would like you to take into consideration this information while discussing the similar type of issues in your country as well. Let me also say a few words about the democratic lawmaking process and equal participation. First of all, I would like to mention the problem of equal participation of underrepresented groups such as women, persons with disabilities, and ethnic minorities, which their participation in political decision-making process is problematic worldwide and is problematic in Georgia as well. For instance, 53% of country's population in Georgia are women, but unfortunately their political representation in the parliament and the local level has not reached up to 15%. As for the equal representation in judiciary, for instance, we have more than 50% of all judges in Georgia. More than 50% of all judges in Georgia are women, but unfortunately there is just few female members in a High Council of Justice, and 4 court presidents out of 26 courts are only women. Also, in this situation, the role of national human rights institutions such as public defender and the role of civil society organizations increase, and is very important to monitor and to advocate the problems of these people, of these marginalized people. Unfortunately, public prejudice, existing political stereotypes, and invisible social, cultural, and individual barriers are creating additional problems and barriers for these people to be equally represented and be equally engaged in public and political life. What can we do? For instance, in order to strengthen the women's political participation, Public Defender is advocating for introducing gender quota, which is, to our mind, instrumental for equal political participation in the existing circumstance. Of course, when we are talking about such an structural and systemic problems such as independence of judiciary and other problems, the equal participation looks like secondary problem, but this is very important, and this is also a very important element of democratic lawmaking. And one thing that I also wanted to mention is the increase of hate speech, especially during pre-election context. The xenophobic, homophobic, and religious hate speech and incitement of discrimination is often part of electoral campaign, not only in Georgia, but in many European countries, and this is the trend, unfortunate negative trend that we have to deal with. And as a public defender, as an equality body of Georgia, very often we issue recommendation and call on the public figures to refrain themselves from making such statements. With this, I would like to end my introduction, and I'm looking forward to your interventions and comments on the situation in your respective countries. Thank you very much.
Thank you very much indeed, Madam Public Defender. Thank you very much for mentioning those important developments which are currently taking place, not only in Georgia, but I would say they very much apply to the whole region. You know, the issue of independence of judiciary. Thank you very much for mentioning important case. I suppose it was Astrason versus Iceland. You know, this will certainly have an impact on other, obviously, participating states, and also for stressing the importance of democratic lawmaking. Indeed, quoting our director, it's not only democracy through law, but also law through democracy. We should all keep it in mind when we are conducting public consultations and allowing to have a due process which will secure the highest quality of law. Thank you very much, and I will try to allocate some time at the end of the session to hear your reflections on the discussion. I've been informed that because of a long list, we can only allocate 2 minutes, 30 seconds for interventions, and please do observe the time. Very quickly, I just want to go through some other important technical remarks. I would like to remind all the speakers that intervention should be presented in a meaningful, orderly, and respectful manner. Please keep comments brief and to the point, and start with your recommendations, please. I would also like to remind the participants that they can only speak in the capacity in which they are registered, and only entities registered on the speakers list can take the floor. And I'm going to police this particular rule particularly strongly. I would like to remind all of us that points of order can only relate to the procedural issues. When it comes to the substance of the matter under discussion, participating states are welcome to use their right of reply. Now I would like to give the floor to the first speaker on our list. It will be Hungarian Helsinki Committee, followed by delegation of United States of America.
Thank you, ladies and gentlemen. Good morning to everybody. My name is András Kádár. I represent the Hungarian Helsinki Committee, one of the oldest human rights watchdog NGOs of Hungary. I am here today to speak about judicial independence in Hungary. Since the ruling party of Hungary came into power in 2010, it has very consciously attacked the system of checks and balances, packed the constitutional court, changed the electoral system, turned independent media into government mouthpieces, intimidated civil society. And now the ordinary courts are under attack. But as judicial independence is monitored very closely nowadays, this is done very cautiously through the administration of the judiciary. The OSCE recommendations on judicial independence warn that judicial administration must be transparent and enhance judicial independence, but Hungary is not complying with these requirements. The head of the judicial administration is the president of the National Judicial Office. She has very extensive powers over the judiciary, but she is chosen by the legislature with no judicial participation whatsoever. The current president also has very close personal ties to the ruling party. The judges' self-governing body, the National Justice Council, is supposed to provide a check on the president's powers, but the council is weak, with limited authorizations and no independent budget of its own. The Venice Commission warned against this situation already in 2012, but to no avail. And in the past years, the president has regularly circumvented the laws, abused her powers, and appointed loyal court presidents against the will of the judges. This is a problem, as court presidents can put a lot of pressure on individual judges through deciding on their promotion, bonuses, working conditions. When the Judicial Council tried to investigate and end this unlawful practice, it came under fierce attack. Many of its members resigned, some allegedly due to threats. Others have been removed from judicial working groups or deprived of their bonuses. Smear campaigns against council member judges are regularly run in government mouthpieces, and members of a judicial association that supported the council were unlawfully blacklisted. Several international actors expressed concern about this constitutional crisis, including Human Rights Commissioner Mijatovic and the Council of the European Union. More about the facts can be heard at our side event at 1:15 in meeting room 3. For now, I just wish to respectfully request you to closely monitor what is happening in Hungary to judicial independence, whether OSCE recommendations are complied with, and support those Hungarian judges who raise their voice for judicial independence, because the damage to independence can spill over borders.
Thank you very much indeed. I would like to give the floor now to United States of America, followed by Russian Federation.
Thank you, Mr. Moderator. I have actually returned to this session from Vienna specifically because of the importance of this issue. If you don't have an independent judiciary, then the public has no choice but to live in terror. So that's why this is so important. The independence of the judiciary is deteriorating in a number of OSCE participating states, which undermines democratic institutions and hampers efforts to prevent corruption and abuses of political power. So here are some examples that we have noticed in the United States. In Russia, the executive branch and security services wield extensive influence over the judiciary and over broad anti-terrorism statutes that give wide berth to politically motivated prosecutions. The NGO Memorial has documented more than 300 political prisoner cases. 300 political prisoner cases. Those responsible for state-sanctioned crimes, including political assassination and large-scale corruption, enjoy near total impunity. When we say impunity, we mean that the bad people get away with it under state sanction. The Russian Federation has been unwilling to engage meaningfully with the OSCE's Moscow Mechanism mission, which found credible evidence that Chechen authorities committed serious and systematic human rights violations and abuses with total impunity, which means they can get away with it, including torture and extrajudicial killings between January 17 and December of 18. Russia's ongoing aggression in eastern Ukraine and its occupation and purported annexation of Crimea have undermined the rule of law in these areas. We urge the Russian Federation to unconditionally release Crimean Tatars imprisoned on false terrorism charges, including 24 Crimean Solidarity activists arrested in March. The only offense is their objection to the occupation, the illegal occupation. Abuse has also characterized Russia's decade-long occupation of Georgian territory, where Russian-backed de facto authorities have failed to credibly investigate the deaths of ethnic Georgians in their custody. The United States is disturbed by credible evidence that a leading suspect in the killing in Serbia of 3 American citizens, the brothers Betice, enjoy impunity, which means the state lets them get away with it, because of his close ties to Serbian leadership. In Turkey, the United States welcomes the release of American citizen Andrew Brunson and acknowledges the release of other American citizens. The United States reiterates its strong concern with the prosecution of consulate employees. Finally, in Kyrgyz Republic, the Kyrgyz Republic is concerned about the near decade-long detention of human rights activists who are suffering from illnesses. These are the observations of positions of the United States, Mr. Moderator.
Thank you very much indeed, Ambassador, and I encourage you to submit the full statement to our documentation center. Now it's my pleasure to give the floor to the Russian Federation, followed by Germany on behalf of the European Union.
Thank you, Moderator. Some states have violated universally recognized principles and norms enshrined in international law, including the fact that it's unacceptable to use torture, the independence of the judiciary, and also the fact that the international community is sitting idly by. All of this threatens the existing world order. We have concerns about access to justice in the Ukraine. Judges are being pressured. Sometimes they're attacked during the court hearings. This is all common currency. Statesmen now often give assessments of court judgments. That's considered normal. Furthermore, the law enforcement authorities are being micromanaged. We've seen illegal detentions accompanied by cruel treatment and the flouting of procedural rules. Paramilitary units are being set up, taking on powers, the powers of the courts and of the investigative bodies. Independent media cannot operate. International human rights defense organizations have recorded over 50 instances of activists and human rights defenders in Ukraine in 2018 being attacked. The notorious website Mirotvorets Peacekeeper is adding new names to the list. If you're on that blacklist, then your health and your life are at risk. We condemn Ukraine's decision to bring criminal charges against the civil society in Crimea because they're participating in the OSCE review conference. We demand that these repressions cease and that civil society figures can continue engaging with international organizations. Against this backdrop, it's worth mentioning some of the systematic human rights abuses in the US. I'm referring to abuses of detainees in prisons. The Ministry of Justice of the United States has recognized that in the state of Alabama, the prison administration is not in a position to protect detainees from violence or sexual abuse, nor can it ensure their safety. For confirmation, look no further than the sudden death in his cell of Jeffrey Epstein. The billionaire with suicidal tendencies was under special observation. However, there was supposedly not enough staff to watch him around the clock, and at that fateful moment, cameras were turned off. According to the American Union of Civil Liberties, currently roughly 100,000 detainees are in solitary confinement. Running afoul of international standards, this situation goes on for years, for decades. Over two-thirds of detainees have been sentenced to life in prison, although the crime they committed was non-violent. We stand convinced that the fact that there's no independent public oversight body in the US controlling the conditions of detention contributes to the violation of detainee rights. We're baffled by the groundless judgments handed down by American courts used to detain Russian citizens across the world. For instance, on the 30th of August of this year, in Italy, Alexander Korshunov was detained. He was accused in the US of collusion and stealing trade secrets. We issue an adamant call for our Western partners to reject double standards when applying their OSCE commitments. We must focus on HR violations. And I will be submitting the full text of my statement to the Secretariat. Thank you very much.
On my list, Germany on behalf of the European Union, followed by Association of Trading Companies of Kazakhstan.
Thank you very much, Mr. Moderator. I have the honor to take the floor on behalf of the European Union, also on behalf of North Macedonia, Montenegro, Albania, Iceland, Liechtenstein. This list of aligned states is not final. The full list will be submitted in the written version of this statement. As you have asked, Mr. Moderator, I will start with the recommendations. The EU has 4 recommendations. First, participating states should undertake all efforts to safeguard human rights and fundamental freedoms through promoting democracy and the rule of law. Second, participating states should preserve judicial independence and counter any attempts to limit the ability of courts and judges to perform their duties free of influence or control by other actors. Thirdly, while recognizing the importance of national ownership in rule of law activities, we encourage participating states to request support in order to improve and strengthen democracy and the rule of law in their respective countries. Fourth and final, participating states should further promote the principles of non-discrimination, gender equality, and women's empowerment in order to foster peace, sustainable democracy, and economic development. These are the 4 recommendations by the EU. A survey conducted by the EU Commission in April 2019 in all EU member states showed overwhelming support for the rule of law. Over 80% of citizens in all member states recognize the importance of key principles of the rule of law, such as legality, legal certainty, equality before the law, separation of powers, and effective judicial protection by independent courts. The EU supports democratization and fundamental freedoms in partner countries, recognizing the crucial importance of encouraging broad participation in political decision-making and local ownership of development processes. The EU recommends and greatly appreciates the work of ODIHR and OSCE field missions in this context. We also support ODIHR's monitoring activities and trials, monitoring activities of trials and elections, helping states to comply with their commitments in the area of the rule of law. The principle of separation of power aims to prevent the concentration of power by providing for checks and balances. The separation of powers is in turn a crucial requirement for judicial independence, as it prohibits the executive branch from interfering in the work of the judiciary. Effective judicial protection by independent courts remains another important cornerstone for democratic societies. We would like to mention two country situations. In Turkey, the EU remains concerned about the human rights situation in Turkey, including the protection of the rule of law, judicial independence, due process, human rights, and fundamental freedoms. In this regard, the EU continues to call on Turkey to respect the international standards and obligations to which it has subscribed and committed itself in order to urgently reverse the negative trend. Also, a second country situation, Russia. The European Union continues to follow with concern the developments in the Russian Federation. Freedom of assembly must be guaranteed for all, including those who wish to express their demand to free and fair elections. Regarding Chechnya, we call on the Russian authorities to incorporate the recommendations from the OSCE Moscow Mechanism Rapporteur, Mr. Benedek, to ensure the effective, transparent, and unbiased investigation of human rights violations in Chechnya. We follow the criminal proceedings against human rights defenders and civil activists like inter alia Yuri Dmitriev, Kirill Serebrennikov, Anastasia Shevchenko, Roman Udot, and Alexandra Koroleva, as well as religious groups like Jehovah's Witnesses.
Yes.
Thank you very much.
Thank you very much, Germany, and I suppose the full statement will be submitted to the Documentation Center. My recommendation to remaining speakers is, first of all, start with the recommendations, and second, please observe the time. Thank you very much. I would now like to give the floor to Association of Trading Companies of Kazakhstan, and followed by International Bar Association's Human Rights Institute. Thank you.
Thank you very much. Good morning, colleagues. It's my first visit to Warsaw, and I'm very surprised that the airport is called the Chopin Airport, an eminent composer, and not President Andrzej Duda. But I think that in the post-Soviet area, in particular in Kazakhstan, it's very important that the law be in fact applied to ensure independence of the judiciary. Quite openly speaking, in our country at the present time, the judiciary acts really as a sham organization. We, as human rights defenders in Kazakhstan, expect that with the new authorities we should move on to reform of the judiciary. In particular, the principle of presumption of innocence is not really applied in Kazakhstan. If legal proceedings are brought against an individual, one preassumes that the individual is guilty. We must understand that today's situation, when in our country these reforms could in fact be taken up by civil society, that would be very important. It's a significant principle, would be having an appropriate way of selecting judges. This is something that could be done in a very short period of time. The new leadership wants to bring into play new mechanisms and establish new relations between the civil service and the population. And such reforms would be very well received not only by our civil society but also by the international community, which has on a number of occasions leveled reproaches at our country, and they were for the most justified. We understand that there is a delicate situation, it's a bit unstable, there is a power play going on among the elites, and but if we do ensure independence of the judiciary, we could root out corruption, and we could ensure equality of all members of society before the law.
Followed by Slovak-Russian Society.
Thank you, Mr. Chair. In the last years, the rule of law in Europe has come under increased pressure. Today we witness an assault on Europe's judicial architecture as populist and illiberal movements in Poland and Hungary try to dismantle the system of checks and balances. In the name of necessary reforms, Poland and Hungary has adopted laws that threaten the judiciary independence and legal protection and attack the very core of the rule of law. Since the political elections held in 2015, Poland has adopted and implemented a set of measures to undermine the independence of the judiciary in Poland. As the International Bar Association's Human Rights Institute, we have on numerous occasions expressed our concern over the adopted amendments to the law on the National Judicial Council, law on Supreme Court, and the law on Common Courts Organization, as well as the law on the Constitutional Tribunal, and the impact of such legislation on the independence of the legal profession in Poland. We see the amended legislation as a grave threat that brings the judicial system under the control of the executive and legislative branches. The law removes the necessary guarantees to protect Polish judges from political control and thus puts the independence of the Polish judiciary at serious risks. By disrespecting the separation of powers principle, Poland acts in contradiction to international and regional treaties. The rule of law in Hungary was undermined drastically by the Fourth Amendment to the Fundamental Law that essentially allowed inserting provisions into the Fundamental Law, which has been previously found unconstitutional by the Constitutional Court. And in this way weakened the control exercised by the Constitutional Court over the Hungarian Parliament. This law effectively dismantled the Constitutional Court and other checks and balances of the governmental power. The IBA's Human Rights Institute calls upon Poland and Hungary to respect the independence of the judiciary and separation of powers principles and take necessary actions to ensure that in practice. Thank you.
Thank you very much for observing time. Now I would like to give a floor to Slovak Russian Society, followed by delegation of Czech Republic.
Thank you, ladies and gentlemen. I start with recommendation. I propose this conference accept the resolution. This conference in Warsaw calls on Russia, Ukraine, European Union to cancel the sanctions against each other. And the reasons: EU declared first sanctions against Crimea in March 14. Ukraine decided various limitations on Crimea in the same time by decisions of constitutional bodies or just limitations that were caused by activities of unspecific groups of persons, and Ukrainian constitutional bodies did not inhibit them and their results did not remove. Ukraine introduced the blockade of the supply of the fresh water to Crimea. By various technical measures, led the fresh water sourcing on the territory of Ukraine but flowing to Crimea to another zones only not to come on territory of Crimea. In this way, Crimea lost 3/4 of the fresh water. Lack of fresh water is causing losing of agricultural lands. Blocking of supply of electricity. In November 15, unspecified persons blowed up 2 poles for high voltage electricity in Kherson Oblast. The result was the shortage of electricity for almost half of the inhabitants of Crimea, including hospitals, schools, and other social and culturally important facilities. Railroads. The government of Ukraine drastically reduced railroads linkage with Crimea. Moving of Crimeans and their goods on the territory of Ukraine was minimized. Blockade of internet, banking sphere, and mobile telephones. On Crimea is not possible to use global credit cards, is not possible to phone by mobile phones with European operators. The opto cables for internet were cut. Crimea had to link everything by pertinent cables of the RF. Ladies and gentlemen, even if EU and Ukraine considers the secession of Crimea illegal, the human rights of ordinary peoples cannot be hurt. Let's consider the difference in approach of the Western countries to Crimea and to Kosovo. Thank you.
Thank you very much, and I would like to remind all the speakers this is a working session 10. The topic is rule of law, and please do consult on the agenda for the content of the session. Now I would like to give a floor to the delegation of Czech Republic, followed by Helsinki Foundation for Human Rights.
Thank you, Mr. Moderator, and good morning to everybody. The Czech Republic would like to align itself with the statement delivered by the European Union. The recommendation now first, we encourage OSCE participating states to use the United Nations guidelines on the effective implementation of the rights to participate in public affairs as a practical tool when integrating civic participation as a human right and a key governance principle and into their laws and policies. Let me emphasize that promotion and protection of participatory rights, including electoral rights, belongs to the national priorities of the Czech Republic's human rights foreign policy. One of the most important activities in this area is the resolution on equal participation in political and public affairs. Since 2013, we have been submitting this resolution to the United Nations Human Rights Council in Geneva, and we would like to use this opportunity to update the OSCE participating states on the recent developments. Since September 2018, the states can find guidance and inspiration in the above-mentioned guidelines. These guidelines, operationalized by the consensual resolution 39/11 of the United Nations Human Rights Council, introduce practical orientation and recommendation for states and as well as for other relevant stakeholders in relation to the effective implementation of the participatory rights. The guidelines can also be instrumental in the implementation of the 2030 agenda at the national level. Since the elaboration of the guidelines, states may request from the Office of the High Commissioner for Human Rights technical cooperation and capacity building regarding the use of these guidelines. Finally, Mr. Moderator, we would like also to use this opportunity to thank the auditor for the outstanding efforts in the above-mentioned fields. Thank you very much.
Thank you very much, Ambassador. I would like to give a floor now to Helsinki Foundation for Human Rights, followed by American Bar Association.
Thank you, Mr. Chairperson. I will deliver a joint statement by the Amnesty International and Helsinki Foundation for Human Rights. Both organizations welcome the discussion on the independence of the judiciary as well as ODIHR's ongoing efforts in safeguarding the rule of law. Distinguished delegates, ladies and gentlemen, since 2015, the governing majority in Poland has adopted nearly 20 pieces of legislation that have undermined the independence of judiciary. The government has politicized the system of judicial appointments, attempted to force Supreme Court judges to retire, and weaponized the system of disciplinary proceedings in case of judges. We have documented several forms of pressure on judges, including attempts to influence the judicial decision-making, intimidation through disciplinary proceedings, and abusive media or social media campaigns allegedly linked to top-ranking officials in the Ministry of Justice. In today's Poland, the government rewards, disciplines, and punishes judges as it wishes. Undermining the independence of the judiciary in Poland is in breach of both EU law and international human rights standards. We call on Poland to immediately stop using disciplinary proceedings against judges in a retaliatory manner and take immediate steps to restore the independence of judiciary. We also call upon OSCE participating states to closely monitor incidents of the rule of law violations and attack on judges. Poland must change course and restore the independence of judiciary. The alternative is, as one of the judges has noted, a loss of judicial independence will cause a damage that will last for generations. I thank you, Mr. Chairperson.
Thank you very much, and I encourage you to submit the full statement to the Documentation Center. Now I would like to give a floor to American Bar Association, followed by Movement for the Renaissance of the Northern Epirus.
Hello. First, I wanted to express our gratitude to the OSCE, specifically to our dear office, for continued support to human rights and for organizing this conference. Judicial independence is the cornerstone of any democratic society. Attacks on the independence of the judiciary and the courts are attacks on the very foundations of democracy and the rule of law. In the absence of judicial independence, journalists, lawyers, and other human rights defenders may face frivolous criminal charges and other forms of judicial harassment. And those judges, prosecutors, lawyers, and other members of the legal profession who advocate for the rule of law and human rights may find themselves under attack for fulfilling their professional obligation to do so. Unfortunately, such appears to be the case in Poland. In the last couple of years, there were several measures taken in Poland that directly undermine judicial independence. These measures have politicized the appointment, discipline, and removal of judges by creating 2 new chambers in the Supreme Court that are responsible for disciplinary procedures and for reviewing electoral disputes that are staffed by the ruling party. The staffing of the majority members of the National Council of the Judiciary is done by the majority in Parliament. Politically motivated removal of judges can have a crippling impact on the court's ability to hold members of the ruling party and the executive branch accountable to the rule of law. I specifically wanted to draw your attention to the use of disciplinary process in a retaliatory manner against judges. The Polish government has created a new judicial disciplinary office and appointed a disciplinary prosecutor to take the cases forward. The highest authority for disciplinary cases is the new disciplinary chamber of the Supreme Court. The ability of judges to render impartial justice, deciding cases according to the law and the facts in front of them without fear of reprisal, is a safeguard of democratic society and the last line of defense for minorities otherwise subject to the majoritarian whims of political branches. The politicization of the disciplinary process directly threatens the independence of the courts and undermines the appearance of impartiality necessary to ensure public confidence in the administration of justice. In light of these concerns, Poland should take the steps to respect and preserve the rule of law, specifically the United Basic Principles on the Independence of the Judiciary, Constitution of Poland, and European laws.
Can I kindly ask my dear friends from American Bar Association to submit their full statement to the Documentation Center? I'm sorry for that, and now I would like to give the floor.
Thank you.
Movement for the Renaissance of the Northern Epirus, followed by Human Rights Lawyers Network Without Frontiers.
Thank you. Honorable delegates, the members of the Greek national minority in Albania face serious problems with the country's justice, particularly regarding property issues. Specifically, the Albanian courts validate even fake documents from the Ottoman Empire or later that the Albanian violators use in order to strip the Greeks of their land in northern Epirus. This phenomenon has existed for decades in most villages. The courts have showed shocking prejudgment in their decision, making the members of the Greek minority lose their trust in the Albanian justice system altogether. The cases are important and too many. In Himara, in Kakomea, in Agisaranda, in Finiki, in Kostari, in Draleo, in Svernetsi, in Drimades or Dermi, in Examili, in Pogoni, and elsewhere. It's now close to a year since the Albanian police killed a member of the national Greek minority, Konstantinos Katsifas, who only wanted to exercise his rights in his ancestral land, but unfortunately no official report has been issued by Albanian justice, thus refusing to shed light on this case. Why? Aristotelis Goumas, murdered on August 12, 2010 in Himara by Albanian nationalists because the victim wanted to speak his mother tongue Greek in his home country. The Albanian justice has released the accomplices of the murder on restricted terms, while the driver of the car that repeatedly ran over the body of Aristotelis Goumas was sentenced to just 12 years in prison, but did not spend 1 day in prison. It's also noteworthy that the victim's family was not called on the court and was not formally informed of the decision. Thank you.
Thank you very much. I would like to give the floor now to Human Rights Lawyers Network Without Frontiers, followed by Open Dialogue Foundation.
Good morning, ladies and gentlemen. I'm speaking on behalf of US-based NGO, Human Rights Lawyers Network Without Frontiers. I'm going to speak about the judicial and institutional bias and misconduct in Croatia based on ethnic origin of the parties. Starting with the recommendations, since the Republic of Croatia is both member of the EU, Council of Europe, OSCE, and the UN, and also ratified all international conventions in the field of human rights and rights of children, we recommend that Croatia honor its internationally assumed commitments, comply with and effectively implement the rule of law standards in each and every case brought before the judiciary, regardless of nationality and ethnic origin of the parties. As an attorney, I have worked on a flagrant case of discrimination based on ethnicity in Croatia. Mr. Dalibor Močević, a Croatian citizen of Serbian ethnicity, suffered inequality and ultimately numerous violations of human rights along with his children and his family before the courts and other government institutions in Croatia. For over 10 years, he and his family members have been victims of discrimination because of his Serbian origin by the judicial authorities. A few examples. Criminal complaints into suspicious death of his mother in Zadar County Hospital in 2009. Failure of the authorities to carry on investigation into those allegations or dismiss the complaints if they are unfounded. Failure to investigate threats he received in late 2010 from known perpetrators. Deprivation of property in the form of forceful eviction and later judicial cancellation of specially protected tenancy rights to the apartment his mother and himself had been living in since his birth. Failure of the municipal court in Zadar and notary public to conduct inheritance proceedings after his late grandmother and uncle, depriving him of property he should have inherited by law. Systemic failure of courts and social work centers to protect his right to maintain personal relations and direct contact with his children living away from him in Croatia. And denial of justice by extreme prejudice against him on an ethnic basis by the family court in Našice. I could further elaborate with a lot of details and evidence, but my full paper will be available on the website of the OSCE ODR later today. Thank you for your attention.
Thank you very much. Now I would like to give the floor to Open Dialogue Foundation, followed by Political Movement Group 24.
Thank you, Mr. Moderator. Ladies and gentlemen, the rule of law in Poland being at risk is visible mostly in the judicial independence being under great pressure today. Judges are constantly attacked not only by representatives of the ruling camp, a group of politically dependent judges employed in the Ministry of Justice, but also the so-called national media and a great part of its public being heavily influenced by information aimed at slandering and smearing the judges independent from political orders. 35 of these judges have already faced persecutions. Let me present you only some of the numerous front-page examples. Judge Łukasz Biliński was transferred to another department after adjudicating repeatedly and lawfully in favor of anti-government protesters. This decision of the president of the court, who is openly subordinate to the Minister of Justice, is seen as a form of repression and warning to other judges adjudicating in similar cases. Judge Igor Tuleya has been repeatedly criticized in the media by politicians for adjudicating in cases described as political even before the verdict, which is perceived as intimidation of judges. National media show him in the worst possible light, in a biased manner and without due objectivity. He and other independent judges are offended and compared to communist apparatchiks, extraordinary caste and vermin which should be exterminated. These are the words that politicians of law and justice directly use in the media. Other judges like Krystian Markiewicz, Piotr Gonciarek, and Monika Frąckowiak are harassed with interrogations and disciplinary proceedings after their statements in the media, public speeches, press publications, and interviews. Judge Waldemar Żurek was already accused and stands trial. Judge Dariusz Mazur was legally harassed, that is, dismissed of his function without justification. Moreover, there happened searches in the offices of judges by Secret Service agents and controls conducted by presidents of courts of the case files without the knowledge of judges. Judges are also subjected to massive attacks from politicians, as in a billboard campaign showing inconvenient judges as thieves and pedophiles, and a recently revealed smear campaign in social media against independent judges that was directly controlled by Deputy Minister of Justice Łukasz Piebiak. As for the recommendations, I would like to ask you to pay attention to the individual cases of judges persecuted, humiliated, and even dehumanized for defending the lawful state. The system violates the rights of the individuals. That's why the state of the rule of law in Poland should be assessed also via recognition of individual cases of politically motivated persecution of judges. Thank you.
Thank you very much. I would like to give the floor now to Political Movement Group 24, followed by Delegation of Malta.
Thank you, moderator. My name is Hasmik Harutyunyan. I represent Group 24 from the Russian Federation. The rule of law and the independence of the judiciary, democratic lawmaking, and the enjoyment of rights and equal participation in public life for all. In fact, the term rule of law should be replaced by the rule of Rachmaninoff in the constitution of Tajikistan. the independence of the judiciary in Tajikistan is a sham. It's fine words written down in the constitution, just like the term rule of law. In practice, the judiciary is in fact part and parcel of the executive. It is simply meting out Rachmanov's punishment. Over the last few years, the judiciary has been used to convict innocent people, putting them in prison for many years. These are political opponents of Mr. Rachmanov. They criticize the regime. They're dissenters. This is evidenced by the convictions of Zaid Saidov, Maksud Ibragimov, and Buzurg Mehrerov. What else can be expected from judges appointed by Rachmanov himself? As for democratic lawmaking, all parties in the parliament are controlled by the regime. There's not a single bill that's discussed or adopted in parliament. In fact, all of the laws serve the interests of the ruling clan. Only laws which serve the interests of Rachmanov are adopted. Over the last few years, all of the legislation that's been adopted has not served the interests of the people, rather the interests of Rachmanov, starting from the ratification of the protocol on the sale of land from Tajikistan to China, to the constitutional law which proclaimed Rachmanov the leader of the nation, which gave Mr. Rachmanov and his family unlimited power. Furthermore, there's the law on the establishment of the so-called Fund of the Leader of the Nation, which funnels budget resources to those in power and over which there is no oversight. There are other similar absurd laws being passed in the so-called democratic land of Tajikistan. No one in Tajikistan has any rights to take part in political and public life. Only Rachmanov and his clan can do so. Those who do want to exercise this right are persecuted, convicted, and are forced to flee the country. Thank you.
Now I'd like to give the floor to the delegation of Malta, followed by Human Rights Alliance of Kazakhstan.
Good morning, Mr. Chairperson. Malta aligns itself with the statement delivered by Germany on behalf of the EU, but I wish to avail myself of this opportunity to make some additional remarks in my national capacity. The very core principle of a functioning democracy is the establishment and the application of the rule of law. Indeed, the application of the rule of law and respect for human rights enhances a society's sense of security. In this regard, Malta fully supports ODIHR's actions in fostering the rule of law within the OSCE region. Mr. Chairperson, kindly allow me to highlight a number of domestic initiatives launched in my country. Since 2013, the Maltese government embarked upon a process intended to reform the national justice system, aimed at strengthening good governance and the rule of law. It is worth pointing out that during 2016, the Parliament unanimously adopted the Constitutional Reforms Act. This act seeks to promote the separation of powers between the executive and the judiciary through a new and more transparent system of judicial appointments, and through an enhanced accountability of the judiciary as a result of the extension of disciplinary proceedings in case of breach of ethics. This further upholds the independence of the judiciary, also through the improved remuneration and the service pension scheme that honors the service of retired members of the judicial bench and their widows or widowers. It is noteworthy that currently the Maltese government is implementing an ambitious law reform program for the strengthening of the independence of the judiciary and respect for the rule of law, including the already enacted new Defamation Act and the Whistleblowers Protection Act, as well as the recently enacted State Advocate Act, which requires the appointment of the state advocate intended to separate the prosecutorial and advisory roles of the Attorney General to the creation of a state advocate. These unprecedented implementations and acts will continue to improve our democratic process, as well as strengthen the quality of the fabric of the rule of law. Malta is also committed to achieving gender-balanced representation and decision-making positions for the benefit of society as a whole. The structural factors that are closely linked to historical and unequal power relations are thus being challenged through a collective effort. Thank you, Mr. Chairperson.
Thank you very much indeed. Delegation of Malta, I would like to give the floor now to Human Rights Alliance of Kazakhstan, followed by delegation of Tajikistan.
Good morning, dear participants in this conference. In Karakalpalstan, everyone knows how Davletbay Shamshetov was repressed by our first president of the Republic of Kazakhstan, Davletbay Shamshetov, and he was forced to sign certain papers, and consequently a supposed accident was organized and he was killed. And for the special operation, an officer of the KGB, Alexander Filatov, was promoted to general. And as of 2005, he became responsible for repression in Karakalpakstan. He also carried out special operations to do away with the declaration in the constitution of Karakalpakstan. You can imagine what is happening to the family members of the political opposition. All of the relatives of Aman Sagigulayev had their property, their livestock, and their farms taken away. Their brothers, his brothers, were beaten up, tortured, and they're invalids for life now. Recent torturing of Iskenderov, Yuldashevoy, Karimov, and many others show what a repressive occupational policy is being carried out by Mirziyayev. In Karakalpakstan, torture has become a very large scale after Shavkat Mirziyoyev came to power. And I would like in particular to mention the torturing of Nushbai Kamiyazev, the grandson of the legendary politician Sultan Kaniyazov, one of the founders of independent Karakalpakstan. He was tied up to a corpse and tortured in order to get him to admit to something that he had not done. He was sentenced to prison for 15 years. And it's been made clear that this is what will happen to anyone who talks about the independence of Karakalpakstan. Uzbekistan is generously rewarding Karakalpakstan politicians for their inhuman torturing. The titles of general have been given to Filatov and many others who were involved in repression. And Kamalov, for instance, for arrests and tortures, was promoted to the rank of general. These people are given homes, cars, and the right to engage in organized crime. I'm very sorry.
I would like to give the floor now to the delegation of Tajikistan. Пожалуйста, Tajikistan.
Thank you, moderator. In Tajikistan, as per the constitution, the judiciary is independent. In fact, it answers only to the letter of the law. All of the judges enjoy immunity. They cannot have criminal charges brought against them. Judges are selected on the basis of merit. Once a judge is selected, he undergoes a one-year traineeship. There is information published on public websites whenever vacancies open. On the 12th of April this year, we adopted a judiciary reform law for the years 2019-2021. Now, as part of this law, this program, there are going to be 4 steps taken. Various activities will take place so as to strengthen the judiciary in the Republic of Tajikistan. We envisage adopting a law on access to information about the work of the judiciary. Legal aid is provided throughout the process. Also, legal assistance is guaranteed by various regulations. There are independent lawyers which are provided to natural persons. The system of free of charge legal aid is funded out of the state budget. This is available to disadvantaged groups of modest means. This is something we're developing at present, in fact. When we began implementing this program, free of charge legal aid, in fact, it's been provided to tens of thousands of men and women. Over 1,000 of the people who have benefited from this program had disabilities. We've also got an internet portal which we've set up. There, we put up information about various regulations. This is all out there on the internet. Natural and legal persons can access that portal and print out various laws and regulation. This is all funded out of the state budget. Thank you very much. Thank you very much.
The next speaker on my list is Association of Lawyers of Russia, followed by Independent Human Rights Protectors. And if I can kindly ask all of us to switch off our phones, that would be much appreciated. Now the floor goes to Association of Lawyers of Russia, please.
Thank you, moderator. The topic at hand today is most topical, not only for the legal community, but for the world as a whole. We believe it's important to guarantee fundamental rights for all and the right to participate in public life for all on an equal footing, not only for citizens of all states, but also foreigners and stateless persons legally present in another state. From a legal standpoint, what we focus on is the laws and regulations governing citizenship and the granting of legal status to foreigners. At present, unfortunately, not all states have a fast-track procedure for certain categories obtaining citizenship. For instance, minors, the legally incapacitated, those who are not fit to work, and persons who have close ties to the state where they live, even if they're not citizens of it. These are often people who've been born in a given state, they've grown up there, they're fluent in the local language, they want to make a life for themselves there and find a job on the territory of that state. In Russia, we do have legislation providing for the streamlining of procedures for issuing permits and citizenship for some categories of foreigners and stateless persons, regardless of where they hail from. Although in many European states there are fast-track procedures, streamlined procedures for foreigners and stateless persons getting citizenship, there are some exceptions. For instance, in Lithuania, only those of Lithuanian extraction can have access to those procedures. In Estonia, only in exceptional circumstances do children born on the territory of that state get granted citizenship. In Latvia, the rules are simplified only for the young and for the elderly. Therefore, in light of the Russian Federation's experience, we believe it's important to take into account the following. First of all, we need to grant and guarantee social and economic rights to foreigners and stateless persons legally present on the territory of any state. We need to streamline the procedures for granting citizenship for persons who have close ties to the state in which they live, those who speak the language, who've been employed there, got an education there, or were born there. We also need to guarantee the right to obtain citizenship for children and offer protection for children of foreign or stateless parents. The right to citizenship is enshrined in the Russian legislation. There's also free of charge legal aid available. We stand ready to contribute to the protection of rights and interests of all persons, including Russians abroad. We will send the full copy of our statement to the Secretariat.
It is Independent Human Rights Protectors, followed by delegation of Spain.
Ladies and gentlemen, judiciary should defend the human rights of individuals and citizens, but in our country it's really not possible to ensure that proceedings brought by citizens are dealt with fairly. In my 10-year practice, I have never seen a real independent judicial decision. In Tajikistan, there is no transparency. Sessions are always in camera, and decisions are taken in a corrupt manner and ordered by authorities or elites. How can you talk about independence of the Supreme Court? The president, the same president, has changed only 5 or 6 judges over the time that he's been in office. And the executive authorities do not treat the judiciary as an independent branch of power. Another factor that gets in the way of the rule of law is the mentality of the people. In the older generation, everyone has been brought up to believe that if someone is charged by the police, then he's automatically guilty. And any proceedings brought by the state have a preordained decision. And there is no real independence of the parliament or competence of the parliament. It cannot elect laws and monitor their implementation. their enforcement. Everything is decided by the President. So what are the recommendations? Well, we believe that the resolutions of the UN and other international instruments must be fully applied in the country. We need to use all of the levers of pressure on the authorities in Dushanbe to make sure that UN instruments are fully applied when it comes to dealing with violations of the independence of the judiciary in the country.
Delegation of Spain, please.
Thank you very much, Mr. Chairman. Spain fully shares the declaration and recommendations that the EU has made on our behalf. Allow me to add some comments in my national capacity, please. OSCE participating states have agreed through their human dimension commitments that pluralistic democracy based on the rule of law is the only system of government suitable to guarantee human rights effectively. Let me stress, pluralistic democracy based on the rule of law. We all agree that human dimension deals not only with human rights, but also with democracy and the rule of law. There is no hierarchy among them. They complement and reinvigorate each other. In this framework, Copenhagen document stipulates in its paragraph 24 that human rights could not be subject to any restrictions except those provided by the law and consistent with other obligations under international law. Mr. Moderator, Mr. Chairperson, el 12 de febrero comenzó en España la vista oral de la causa en la que...
Mr. Moderator, the review of a case where two people have had charges brought against them, the so-called Catalan independence process. You see, in this case, the people in question are in a difficult situation because we cannot have the case heard in absentia. This is as per our criminal code. If I may, I'd like to remind everyone that the Copenhagen document,
to quote, the duty of the government and public authorities to comply with the Constitution and to act in a manner consistent with law. And in its paragraph 5.5 stipulates that the activity of the government and the administration, as well as that of the judiciary, will be exercised in accordance with the system established by law. Respect for that system must be ensured. Moreover, in Helsinki in 2008, in our document further strengthening the rule of law, participating states were encouraged to enhance efforts for that purpose, inter alia effective right to a fair trial, access to court, accountability of state institutions and officials, respect for the rule of law in public administration, and the right to legal assistance. Thank you very much, Mr. Chairman. Let me conclude. This is just an example of the commitments of human dimension that Spain's unwavering commitment to comply with our human dimension acquis and its promotion in the coming years is clear, and sometimes Spain has gone beyond many times of our commitments. Let me say, my last idea, let me say that the trial I referred before is streaming, just like this meeting, the HDIM meeting right now. Thank you very much.
Thank you very much, Madam Ambassador, and please submit your full statement to the Documentation Center. Now I would like to give the floor to Kazakhstan News Channel, followed by Western Trace Minority University Graduates Association.
Good morning, participants. Unfortunately, this is our last day here at the conference. Our families are being threatened in Karakalpakstan by the authorities of Uzbekistan, and so we have to go home. We're faced with various problems, but the cause is always the same. The Mirziyoyev regime is putting pressure on us simply because we are speaking out here. Our family members are being threatened with dismissal from employment by officers of the security agency of Uzbekistan, and so we had to put off our roundtable on 26 September. How can we fight against this lawlessness? We really need to instill the rule of law in our country.
Subject of this session, please.
I would like to kindly remind the delegation that point of order can be made on the procedural issues, and I would like to encourage kindly delegation to exercise the right of reply. And I will return the floor to the speaker, please.
We have distributed to all participants in the conference this Declaration of Independence of Karakalpakstan. This is the basic law of Karakalpakstan. In accordance with this declaration, I'm a representative of democratic choice of the Republic of Karakalpakstan, and I represent the supreme authority in the Republic of Karakalpakstan, and I'm supported by the following parties: Alga Karakalpakstan, Oyan Karakalpakstan, Aral Tolkini, Alpamas, and others. The authorities of Uzbekistan have no legal basis in international law and standards to be present in the Republic of Karakalpakstan. Please read through this declaration. On the basis of point 4 of the Declaration of Independence of Karakalpakstan, I, Karlubay Bek Muratov, in accordance with the systematic violation of human rights, occupation and usurpation of the natural resources and destruction of the people of Karakalpakstan, I would call on the Secretariat of this conference and participants to look through all agreements and contracts on the basis of which the government of Karakalpakstan is governing Uzbekistan is governing in the Republic of Karakalpakstan. We, Democratic Challenge of the Republic of Karakalpakstan, are calling for all military of Uzbekistan to be withdrawn from the territory of Karakalpakstan. Democratic choice of the Republic of Karakalpakstan, in agreement and with the support of the OSCE and the UN, want to have a truly democratic state of Karakalpakstan to be established and for us to enjoy parliamentary democracy.
Followed by Eurasian Dialogue Institution.
Thank you very much, Mr. Moderator. My name is Pervin Hayrullah. I am representing the Turkish minority in Greece. The rule of law is a fact of justice. There can be no arbitrariness in the application of laws, legal rules, or international provisions. However, in some countries like Greece, it is unachievable, as the government officials do not conform to the law. The leader of the New Democracy Party, now he is Prime Minister, Mr. Kyriakos Mitsotakis, stated that the separation of powers and even democracy in Greece are being undermined by government intervention in the judicial system. On the 3rd January 2019, he said that rule of law in Greece is under threat. Prosecutors involved in Novartis case are publicly threatened by top minister. The next elections will be about the economy, but also the quality of our democracy. From the minority perspective, it is possible to say that in Greece, the rule of law is inaccessible. The Greek authorities do not take into consideration the Turkish minority during the legislative process. So the minority policy is not inclusive, but entirely exclusive. In September and October 2017, the Greek parliament voted legislation regarding freedom of association that allowing the reopening of proceedings after the European Court of Human Rights decisions. The first attempt in September failed. In the second attempt, admissibility for reopening of the cases was restricted. The Turkish minority associations that are considered to be a threat to national security and public order were excluded from the reopening procedure. This was clearly stated during the debates in the parliament. After the adoption of the new law, the Greek authorities expressed that legislation was voted by the 85% of the MPs. However, they didn't consider that all 4 MPs of the Turkish minority, that is 100%, voted against the law. Therefore, Mr. Moderator, the Turkish minority calls upon the OSCE participating states to monitor and identify the problems regarding the rule of law and judicial independence in Greece, to encourage the Greek authorities to review her minority policies and to be more inclusive. Thank you for your attention.
And thank you very much for observing time. I would like to give the floor now to Eurasian Dialogue Institution, followed by Glacier Moglikaiken voor allen.
Ladies and gentlemen, judicial decisions are often simply replying to the orders of certain people. And in fact, since 2015, we've had a number of such examples. Some were accused of attempting to overthrow the government. Now, I don't know much about the legal niceties. I'm not a lawyer. However, the UN Human Rights Council recommended that the Republic of Tajikistan free Mahmoud Ali Khaitov, the person accused, the main defendant in that case. So clearly, there is no impartiality here. All of the repressions against the members of this party, but also lawyers, public figures, journalists, all of them have been affected. And the evidence is very flimsy, and in fact, it's considered a state secret, so we don't have access to it. The hearings were held behind closed doors, and the defendant was not there. So the court has basically convicted the leadership of the party. This was a politicized case. And as a consequence, there was not a single judge who could overturn that ruling vis-à-vis any member of the party. Of course, promises have been made that we will be pardoned. And as we've seen over the last 2 years, we have members of the Islamic Renaissance Party here today who have been pardoned in the past. However, there are many more who remain behind bars, who are not part of the amnesty, or some in the room, either they're terrorists and the cases against them have been fabricated, or they're guilty. So the third thing I want to say is that in Tajikistan, we have the prosecutor, the judge, and the executioner are one and the same person, the leader of the nation. And they want to use legislation to make it all seem legal. In terms of recommendations, what I suggest is that everyone in the room insist that the Tajik government implement the recommendations of the highest international body in the sphere, that is the UN Committee on Human Rights, which called for the freedom of political prisoners in Tajikistan. Thank you. Thank you for those recommendations.
Moglikaiken voor allen, followed by Tajik Center for Human Rights.
Dear colleagues, I'll start with an appeal. Dear President Donald Trump, before sending you this letter, writing you this letter, I very much hoped that in Uzbekistan there would be a fair and just judiciary. This is an extract from an appeal to President Trump by a former police officer who's calling for rehabilitation. His guilt had to do with the fact that he initiated a criminal proceeding against members of the authority in power. Now, in connection with the organization of international meetings in Uzbekistan, there is a massive killing of cats and dogs. There's only one shelter for them. Now, this is a barbarous act, but it's a standard in Uzbekistan. On a number of occasions, activists have tried to bring to an end this horrible killing of friends of citizens, the cats and the dogs in their homes, but they haven't succeeded. So I would call on the authorities of Uzbekistan to bring to an end this killing of animals, that they set up for shelters for animals in all cities so that they have a chance to survive. And I would call on the international community to interfere in the actions in Uzbekistan. The Kremlin is deploying a repressive policy. They're turning Stalin into a hero. Here's a photograph of Stalin from just a few years ago. That aggression should be brought to an end. They want to reconstitute the Soviet Union, and yet their family members, their children, go and live in the West. Mirzaev should be arrested and brought criminal proceedings brought against him for the fact that he illegally usurped power, for the fact that he has killed a large number of opposition politicians.
Topic of the session. This is the rule of law session, the number of issues which we're supposed to discuss, and any departure from the subject, I will have to interrupt speakers. Okay, next on my list is Tajik Center for Human Rights, followed by Italian Federation for Human Rights.
Sehr geehrte Damen und Herren, ich heiße Sulaiman Arzeev.
Ladies and gentlemen, my name is Sulaiman Arzeev. Ladies and gentlemen, one of the foundations of a democratic society is the separation of powers. In Tajikistan, in 2016, legislation was adopted with a view to ensuring the fundamental freedoms and the civil liberties of the population. In keeping with this piece of legislation, all three branches of power, the executive, the legislature, and the judiciary, must be separate and act separately. However, what we see in practice is that this is not happening. The executive has all the power. In particular, the head of state, who is free to meddle in the affairs of all of the other branches of government. That is the legislature and the judiciary. Furthermore, I should also like to ask a question. I'd like to put this question to all of the branches of government. Why is it that the security services, why is it that they're free to do anything they wish? Civil servants, security services operatives answer only to the leader of the nation. Why is that? They have to execute his orders instead of applying the laws of the land. By way of conclusion, I'd like to share some recommendations. These are addressed to OSCE participating states. We call on you to fight for the revoking of these laws.
Thank you very much. I would like to give the floor now to Italian Federation for Human Rights, followed by Association of Tajiks in Kazakhstan.
Thank you, Mr. Chairman. The Italian Federation for Human Rights organized international human rights monitoring missions to Kazakhstan. As a volunteer of FIDO, I've been observing political trials in Kazakhstan since April 2019. The judges of the Supreme Court of Kazakhstan are nominated by the President of Kazakhstan and confirmed by the Senate. Judges of Court of Appeals, city and district courts are appointed by the President of Kazakhstan. From October 2015 until October 2018, the European Union invested 5.5 million euro to support the judiciary reform in Kazakhstan. Based on data of the Supreme Court of Kazakhstan, more than 98% of sentences are convictions. Although the Supreme Court states that the number of acquittals is increasing, the percentage of convictions remains extremely high due to the increase of number of cases. Therefore, only 1 in 1,000 cases is acquitted. In case of political prisoners, the authorities set the following condition: plead guilty in exchange for release or reduction of the sentence. Serikjan Bilash, who defended the rights of Muslim minorities in Xinjiang, and Max Bokayev, one of the activists of land protests in Kazakhstan in 2016, reported that representatives of the presidential administration gave them the opportunity to repent in exchange for their release. It confirms the lack of independent judiciary in Kazakhstan. Chairman of the Aktau City Court, Malik Kenjaliyev, was removed from his office after passing an acquittal in the case of Aygul Akberdieva. He recorded his conversation with the chairman of Mangistau Regional Court, in which it's clearly heard that Mr. Kenjaliyev was given the order to punish Aygul Akberdieva. During protests from 9 to 12 June in Kazakhstan, 965 peaceful protesters were tried at night in police stations without lawyers, as it was practiced in Soviet times when so-called special troikas, including a policeman, prosecutor, and judge, who issued fines and sentences after simplified, speedy investigations without a public and fair trial. We deeply concerned that diplomatic missions in Kazakhstan rarely observe trials and urge OSCE member states to encourage their embassies in Kazakhstan to actively visit and monitor political trials. We call on OSCE member states to stop investing in judiciary or other reforms aimed at promoting democratic changes in Kazakhstan until all recommendations of the UN bodies and the European Parliament are implemented, and instead provide financial aid to the civil society, including human rights defenders. Thank you, Mr. Chairman.
Thank you very much indeed. And I would like to give the floor now to Association of Tajiks in Kazakhstan, followed by Paris Bar Association.
Good morning, ladies and gentlemen. My name is Izhushev. The rule of law is an important aspect in the development of any society. A society must be able independently to choose its own governing system. And for this, the appropriate conditions must be put in place in order that political parties be able freely to participate in the political life of the country. At the present time, political parties act freely in Tajikistan. To have a program for political parties, we have all of the conditions, and we Tajiks in Kazakhstan welcome the activities of all political parties that on a legal basis do in fact function on the territory of Tajikistan. And we as an organization do not understand Group 24 and others that are acting in an illegal manner, and they are therefore a threat to peace and stability not only in Tajikistan but in the region as a whole. Given their participation in this forum, I can really understand why Group 24 and others like that are acting the way they are. They are associated with the terrorist Islamic Renaissance Party. So we believe that appropriate measures must be taken in order that these bandit-type terrorist organizations, the Islamic Renaissance Party and the Group 24, that they not be able to use an international forum in order to advance their own self-interest.
All the remarks to be made in an orderly and respectful manner, especially when we are referring to other colleagues in the room. Thank you. Now I would like to give the floor to the Paris Bar Association, followed by delegation of Ukraine.
Thank you, moderator. I'm Vice President of the Paris Bar, which is one of the largest bars in Europe and perhaps even in the world, and I'm also President of an international clearinghouse to monitor lawyers in danger. And I can tell you that there is no modern democracy without the rule of law. There has to be full respect for fundamental principles, separation of powers, and independence of the judiciary in particular. And there is no independent judiciary without fair trials and full respect for the rights of the defense in any legal proceedings. Now, there are serious problems, serious violations of this, which are affecting the profession of lawyer around the world, many threats to the independence of lawyers. This independence is being undermined by disciplinary proceedings, by deletion of lawyers from the list of the bar, even physical intimidation, and even executions or murders. Lawyers have been targeted by governments, by private organizations, simply because they were acting in the interests of their clients or because they were defending causes that governments do not agree with, do not accept. For instance, on 18 September last, the Dutch lawyer Dirk Wiersum was shot outside his apartment, and he was killed. because he had represented an important witness in a case against well-known drug lords. So he was murdered simply because he was working as a lawyer. This situation requires that we clearly define what are the unacceptable attacks on the rights of individuals and the rights of lawyers to represent their clients with no interference, with no outside pressure, and with full respect for the principle of professional secrecy. A strong bar association can clearly articulate the concerns of the profession and guarantee the independence of lawyers and therefore the freedom of citizens. The Paris Bar calls on the members of HDIM to support the International Day of the Lawyer in Danger on 24 January 2020. It's an international day every year. This year it will be dedicated, or next year it will be dedicated to lawyers in Pakistan, and to guarantee the independence of bars and lawyers and to consider this to be a pillar of the rule of law, and also calls on member states of the Council of Europe to support the adoption of a European Convention on the Profession of Lawyer in accordance with the recommendation of the Parliamentary Assembly on the same subject. Thank you.
Islamic Renaissance Party of Tajikistan. Delegation of Ukraine.
Спасибо, господин председатель.
Thank you, Moderator Igor Benimsuk. I am part of the Supreme Court. I've also been a member of the High Council on Justice for a number of years. First and foremost, I should like to thank the organizers of this event for giving me the opportunity to speak. Slovakia, which holds the chairmanship, also deserves our gratitude for agreeing for running the event, and also to our Polish colleagues for hosting it. For us, an independent judiciary is part and parcel of the rule of law. In Ukraine, over the last 4 years, we've seen unprecedented upheaval in the judiciary. In fact, the judiciary has been transformed following the dignity revolution. Thanks to democratic institutions, first and foremost the European institutions, and also the assistance of the United States of America, we've implemented a judicial reform in Ukraine. The High Justice Council was set up. It guarantees the independence of judges and has broad powers. For instance, politicians no longer influence the appointment of judges, career progression, and so on and so forth. So it is only the High Council which can decide to dismiss judges as things stand. Furthermore, we now have budget funding for the judiciary enshrined in the regulations. Moreover, it's clear which legislation applies to the judiciary now. On top of that, we've recently appointed judges to the Supreme Court as well as the Anti-Corruption Court. This was done on a competitive basis. The Anti-Corruption Court is, by the way, working most effectively and enjoys the trust of the public. However, I must say, and this is something that the moderator mentioned, simply adopting legislation is not enough, as often this process is not transparent. Sometimes laws are adopted very swiftly, and this in fact hamstrings the Supreme Court and other aspects of the judiciary, including the judiciary oversight bodies. I'm of the view that all of this attests to the fact that there's a threat that the judiciary will be subject to undue influence. However, those gathered in the room today, representatives of the Russian Federation, as they said, are most worried about the human rights situation in Ukraine. Well, I'd like to tell them that they should put their house in order first before talking about the problems in Ukraine.
Meet your very important remarks to the Documentation Center. This is always appreciated. I would like to give now a floor to Islamic Renaissance Party of Tajikistan, followed by Azerbaijan Institute for Democracy and Human Rights. If the representative of Islamic residence as part of Tajikistan is not present here, we will move to the next speaker on the list, Azerbaijan Institute for Democracy and Human Rights. Please, the floor is yours.
Thank you, Mr. Chair. My name is Ahmad Shadov. I represent Azerbaijan Institute for Democracy and Human Rights. And in my speech today, I want to give a brief overview of the state of democracy in the South Caucasus and make a number of my recommendations. In particular, I want to talk about the rule of law and the democratic situation in the Republic of Armenia, because today all laws in Armenia are subject to the will of Prime Minister Nikol Pashinyan. Armenia is increasingly becoming an authoritarian country as is moving away from the fundamental principles of the OSCE. I want to remind Prime Minister Nikol Pashinyan's call to attack the court buildings in Armenia. The Armenian authorities who hold legal cases against their political opponents and arrest them are already choking free speech and democratic values in Armenia. Armenian activists are trying to save their lives from political persecution because Armenia has become a useless country for survival and political struggle. Prime Minister Nikol Pashinyan dismisses judges in the country and appoints his men as judges to easily overrule his political opponents and take control of all courts in the country. The actions of Prime Minister Nikol Pashinyan are not only at the local level but also in the international arena. I want to draw your attention to the recent speech of Armenian Prime Minister. In his speech, Nikol Pashinyan repeatedly stated that Nagorno-Karabakh is Armenia and that's all. I think these statements are disrespectful of the Armenian authorities against international law, the basic principles of the OSCE and everyone sitting here. I ask everyone here why OSCE works, why the OSCE Minsk group is engaged in conflict resolution if the OSCE does not provide a legal assessment of the statements by one of the conflicting parties. At the end, I urge all participants here, the OSCE member states and the OSCE institutions to evaluate this fascist and authoritarian behavior of Armenian Prime Minister. Thank you for your attention.
Thank you. The next on the list is delegation of Kazakhstan, followed by International Association of Independent Democrats Against Authoritarian Regimes. Delegation of Kazakhstan, the floor is yours.
Добрый день.
Good morning, dear participants. We have a draft law in the Republic of Kazakhstan on criminal legal proceedings. We've produced a green book on the model of the white books produced by the Parliament of the United Kingdom, and it is open for public consultation. And after the consultation with the public at large, we will then produce a white book or a white paper with the position of the government on how this particular area can be covered and the overall criminal proceedings acts as possible when there is some indication of an ineffective action of the legislation. Then monitoring is carried out. The green paper contains a number of indicators and also an assessment of various assessments. And this green paper or green book will also set out the target groups for holding public consultations, how they will be informed, how the exchange will work, and citizens can gain access to this and submit their comments on the corresponding internet page. And the comments can be written in advance of public hearings. At the public hearings, anyone may participate. Any citizen wishing to make a statement can register and do so, and after the conclusion of the public consultations, we will produce a new version of the green paper for the preparation of the subsequent white paper, and an interministerial committee will use all of this input to come up with a draft law. So the opinions of all citizens will be taken into consideration if they wish to participate in the public consideration. Currently on the internet page, citizens can gain access to the drafts and submit proposals for improving them. And in the future, we intend to follow the good example of the Russian Federation and introduce a system of individual petitions that will make it possible for citizens to contribute to the socioeconomic and political lives of their regions and of the state as a whole. Thank you. And thank you to you, says the moderator.
Regimes followed by Informational Resource Center.
Thank you. There are dictatorship states, Azerbaijan, Belarus, Turkmenistan, Tajikistan, and aggressive Russia, and again Uzbekistan. Kazakhstan has an authoritarian system. The dictatorship states have not any independent judiciary. There are not democratic lawmaking. Azerbaijan, the dictator Ilham Aliyev showed it. He is the law. He with the fake constitution, Article 101. Called extraordinary election of the president of Azerbaijan, his election. This is the next violation of the democratic legislation. The dictator Aliyev appointed his wife to be the vice president. Belarus. The dictator Lukashenko does not respect his constitution. Lukashenko appointed election to the fake parliament in November. It is very hard violation of constitution. There are very hard conditions with constitution for the stop the activity of the parliament. Today, Belarus has no same condition. Next violation by dictator Lukashenko, problem for young people. But this November, they have not this right again for participation. After 10 months, the very many people, young, have right citizen, the right for the participation in election. Today, it is not. The young student made the application to Minsk court for the trial. She wait the judgment for the illegal order of the dictator for the date election. But the court made the rejection of application. Dictators of Turkmenistan, Berdimuhamedov, Tajikistan, Rahmanov have not the time for the game in the democratic lawmaking. And United European Union, Germany was in our, today Poland. Poland has no democratic lawmaking. The case of the discrimination has not an ethic of the criminal code. The Polish court reject all applications with discrimination. And more, the Polish court uses illegal method to stop the application of Belarusian person. The defamation has not the special ethic in Polish legislation. The result, the Polish court reject the application of Belarusian person against the Polish official. Thank you.
Thank you very much. The next on the list is Information Resource Center, followed by the Public Project Establishment.
Over the last few years in the Republic of Kazakhstan, the issue of civic participation has gained prominence. The government has sought to strengthen civil society in the country and, in fact, has enshrined this in various strategic plans. We have a National Council of Public Trust headed by the President. This council will issue recommendations for various topics of national interest. This is a way for us to ensure openness and transparency. It's a way to exercise public oversight over the work of the government, ensuring that budgetary resources are used effectively to provide services to the population and to combat corruption. This has been done in Kazakhstan. Just like in many other developed countries, civil society is flourishing. We are ensuring that the interests of the populace are upheld. There are many ways, many mechanisms for engaging people in civil society, in government decision-making. If we look at the experience that's been accumulated in various countries, there's no one-size-fits-all solution, one-size-fits-all recipe for engaging people in civil society. What's worrisome is limited citizen participation in discussions on a number of issues. There's an absence of an institutional footing. Let me focus on a few key areas of cooperation. First of all, consultations, expert assistance from the OSCE, exchange of best practices and information so as to bolster the effectiveness of various consultative bodies. Bolstering governance mechanisms in line with the UN, and also setting up various bodies so as to increase the participation of citizens in public life by way of national reforms, including reforms of various public councils. We also want to increase exchange of knowledge and bolster democratic institutions involving various NGOs and think tanks. Thank you. Thank you very much.
Public project establishment followed by regional center of new information technologies.
Mr. Moderator, dear participants, the Republic of Kazakhstan over the last 2 to 3 years has achieved some success when it comes to combating corruption. But this is due to the fact that the country has left a sort of a red warning area. The population has been consulted to a greater extent. There's more cooperation with the state structures, and so they are attempting to resolve this problem. But this trend shows that the paradigm of corruption at the highest level is quite stable and well entrenched. I can give you examples of projects to build colonies, special groups. There are various mechanisms at play that show that the authorities and the population have started to cooperate more closely to resolve the problem of corruption. But the measures are not only in accordance with the fourth round of the Istanbul Convention to combat corruption, but there is more activity of the civil society. What is most topical in this regard? We need a closer mechanism or a more well-defined mechanism in order that the positions of different parties and different institutions be taken into consideration when adopting certain measures to combat corruption. Yes, there is some dynamism underway, but it needs to be done in full clarity and transparency when it comes to setting up anti-corruption mechanisms. It's not just a question of talking to various institutions of civil society, but also taking into consideration the opinions of all social groups, even if they are small and vulnerable. The principle of complementarity must be fully applied. In Kazakhstan, we need a system to stimulate the activities of citizens in order that civil society flourish and develop. But individual activists are not always fully supported in the deployment of their initiatives. Should that be done, we can improve further. Thank you.
It's the International Hungary.
Good morning. My name is Evgeny Varandukhin. I'd like to raise the issue of sentences meted out by the courts. Some of these sentences are far too lenient, sometimes they're far too stringent. In this respect, I want to make the following point. For instance, when torture is committed, sometimes very lenient sentences are meted out. For instance, we've had cases where torture was committed. In fact, in some cases there were deaths, and charges were brought against the torturers. 5 to 7 years behind the bars. Behind bars is what they were given. So the courts exercise discretion in meting out sentences. They're selective. In other cases, we have very similar sentences. In other words, sometimes the sentences are disproportionate. This is something we need to combat. The sentence must be commensurate with the crime committed. Although there are some bright spots, For instance, over the last 5 years, over 170 law enforcement agents have been held accountable for the crime of torture. However, I don't have any statistics regarding the punishments, the sentences they were given. Therefore, I believe that we need to do more in order to improve the judiciary in Kazakhstan. First of all, influence on judges. If decisions which are clearly unlawful are handed down, we need some kind of mechanism for challenging them. Next, judges should be elected for a fixed term. They should not be appointed for life. Third, jury trials should be introduced not only for serious crimes, but also for more minor offenses. And one more point on legislation.
You submit your recommendations and full statement to the Documentation Center. I would like to give the floor now to Amnesty International Hungary, followed by Salut at Miresi Korde.
Thank you very much, Chair. As requested, I'll be starting with the recommendations. So, ladies and gentlemen, I would respectfully request you to continue monitoring the situation of judges and the independence of the judiciary in Hungary, and support the members of the judiciary who face public shaming for publicly criticizing interference in the independence of the judiciary. I would like to also urge the government of Hungary to fully comply to its human dimension commitments, including the Moscow document, as well as to fully implement the Kiev recommendations on the independence of the judiciary. Ladies and gentlemen, the independence of the judiciary in Hungary is under severe threat. Among several alarming developments, I would like to draw your attention particularly to two issues: the pressure on individual judges and the administrative court system. Following a years-long campaign against independent civil society and the human rights defenders, the pressure on individual judges has further increased. The government-aligned media has targeted the President of the National Judiciary Council as well as its members. The aim of the attacks was to discredit the members of the Council as well as individual judges who have publicly criticized the judicial administration. In July 2019, the Hungarian National Authority for Data Protection found that in February, a regional court president illegally blacklisted 51 judges in his district who were members in a judges' association. On the 12th of December 2018, the Parliament adopted the laws on administrative courts, which were subsequently heavily criticized by regional and international bodies. The laws envisaged a new court system where very extensive powers are concentrated in the hands of a few stakeholders, and there are no effective checks and balances to counteract those powers, as the Venice Commission put it. In May 2009, the Prime Minister Chief of Staff announced that the setting up of the administrative courts would be indefinitely postponed. Despite the adoption of the postponement law in July, there are signs that the government will eventually aim to reintroduce the administrative courts. In July, the Speaker of the Parliament told the radio news channel that the postponement is only temporary, and when the time is ready, the Parliament will relaunch the act. Furthermore, the fundamental law of Hungary still obliges the state to establish the administrative courts in the future. Thank you very much.
Thank you very much, and I would like to give the floor now to Salut at Miresi Korde, followed by Eastern Human Rights Group.
Recommendation. We want to put an end to the influence exercised by the Organization for Islamic Cooperation over the Western judiciaries. Let me give you an example. The European Court of Human Rights upheld the conviction by Austrian courts of Ms. Elizabeth Sabadic-Wolf, who was guilty of reminding us that Muslim traditions themselves recognize that Muhammad, then 54, took Aisha's virginity. She was 9. The court ruled on the basis of the following: that we need to protect the right of plaintiffs to hold religious beliefs, and 2, that we need to preserve religious peace in Austrian society. Turning to the first reason. Now, can we not recognize that there's nothing religious about deflowering a 9-year-old girl, even if it was Muhammad that did it? There's nothing to boast about. How can we explain this monstrous moral obligation on the part of the court, unless it is because the court fears Islam, to such an extent that Muslims, Allah, in fact, is saying that he's been outdone by Muslims, strike terror into the hearts, strike more terror into everyone's hearts than Allah, because these people just don't understand. But clearly, Europeans have understood, and that this is the case. In the Secretary General of the Organization for Islamic Cooperation said that the fight against Islamophobia and all of our points of view that we've raised over many years have been adopted and recognized by the European Court of Human Rights. This decision is wholly satisfactory. Well done, European Court of Human Rights. Turning now to the second grounds. It's a tragedy that the European Court of Justice did not rule on the veracity of the allegations, but rather it thought about what its decision could provoke, kind of repercussions its decision could provoke. Just like Pontius Pilate all those years ago asked what is truth when he released the insurrectionary and murderer Barabbas and convicted Jesus. Similarly, by upholding the Austrian court's decision, the European Court of Human Rights whitewashed and condemned an innocent woman because they feared that Muslims would be committing further crimes. This means that while the European Court of Human Rights condemns blasphemy against Muhammad, even if it is not afraid of, although it is afraid of condemning those who commit blasphemy against Christianity.
Please do submit your full statement to the documentation center. I would like to give the floor now to Eastern Human Rights Group, followed by Gaspijski Institute for Geostrategy.
Good day. Thank you for giving me this opportunity to take the floor as a representative of the Eastern Human Rights Group. It's my honor to represent that group and to say a few words about violations of human rights that are connected with poorly functioning judicial systems. What do we observe in the east of Ukraine? Since 2014, part of the territory has been occupied by illegal armed groups, the so-called LNR and DNR. And we can see there an active support for these terrorist organizations by the Russian Federation, which is attacking the eastern part of our country aggressively. Insofar as access to the judiciary is concerned, in the occupied territories, there are quasi-courts, quasi-tribunals. For instance, the courts of the so-called Donetsk National Republic in the center of Europe in 2019 is sentencing people to the death sentence. The Article 53 of the so-called Criminal Code of the so-called DNR does provide for this, according to the information that we are actively collecting through our monitoring activities of human rights in the territory controlled by these groups. We have information that such cases have occurred, that the death sentence has been practiced. Insofar as access to the courts in those territories is concerned, I do not share the optimism of those monitoring the judicial reform. People sometimes wait for years and years to obtain decisions because the courts in Ukraine, in the part of Ukraine that is controlled by the authorities, are overloaded. In Ukraine, there are courts where there are no judges, or there are judges who don't have full powers, and that is a very serious threat for human rights, this lack of access to the judiciary. And I'd like to say a few words about other negative aspects, a non-fulfillment of sentences by judges. People working in mines in the east of Ukraine who appeal to the courts for certain decisions, unfortunately, just because they get a sentence, it doesn't mean that that will result in any effect whatsoever. Thank you for your attention.
Followed by delegation of Armenia.
Mr. Moderator, participants of this meeting, my name is Nariman Ustaev. I am a director of Gasprinsky Institute for Geostrategy, Ukraine. The current situation in Crimea is such that democratic and transparent lawmaking and participation in political and public life are de facto impossible. Moreover, Crimean Tatars have been the most vulnerable group in their historical homeland for 5 years now. In this context, I want to consider in detail 2 aspects. The first one, Russia conducted illegal local elections in Crimea early this month in the framework of all Russia local elections. It is known that some Crimean Tatars were involved in the organization of these elections under the threat of persecution. The actions of Russia are clear to us here. Obviously, Russia attempts to legitimize the illegal annexation of Crimea, including by faking democratic participation of citizens in public and political life in Crimea. We demand from Russia to stop constant pressure on Crimean Tatars when some of them, under the threat of loss of their business, freedom and illegal persecutions, are forced to participate in political process, and also to involve their relatives, employees and other dependent persons to be engaged into such process too. We propose that the OSCE member states and the OSCE in particular make a statement on the non-recognition of illegal local elections in occupied Crimea, and we are grateful to those friendly nations which have made such a statement already. The second one, the illegal administration in Crimea is now claiming to rename Crimea to so-called Tavrida. Of course, this is an absolutely absurd idea, but we are witnessing that is in such a way Russia is trying to change the DNA of Crimea and to erase the historical link between Crimea and the Crimean Tatar people. And then perhaps next time journalists and civil society representatives of so-called Russian Tavrida would make a speech on international platforms. It should be considered that in conditions of hybrid war, Russia should be expected to use any tool of influence. Thank you.
The next on my list is delegation of Armenia, followed by Commission of the Protection of the Illegally Accused. Delegation of Armenia.
Thank you, Mr. Moderator. The advancement of the rule of law and democracy is at the core of the policies of the government of Armenia. It is necessary to note that after the non-violent revolution, the newly elected Prime Minister Nikol Pashinyan from the very first day raised the issue of the restoration of public trust towards the independence of judiciary and judicial system. The new government proclaimed the rehabilitation of judicial system as its priority. The Prime Minister of Armenia has emphasized that having a truly independent and impartial judicial system is a vital necessity for Armenia, and the lack of such a system is a serious challenge. The Prime Minister emphasized that there cannot be such a judicial system, the power of which does not stem from the people. The road to eliminating vicious practices within judicial system, recovering it, and reaching the trust of public, the government sees through the judicial and anti-corruption reforms. During this time, a very effective cooperation was established with the specialized bodies of the Council of Europe, including Venice Commission, as well as the UNDP and the EU. With the participation of international partners, representatives of civil society, the government now finalizes the reform packages in these 2 directions. In September, the strategic document will be confirmed, and during the autumn session, core legislative packages would be presented to the National Assembly. The ongoing changes are profound and irreversible in Armenia. Changes are initiated by the government, which has the strong mandate and legitimacy entrusted by the people of Armenia. I would like to encourage ODIHR to continue to support participating states to measure progress on rule of law, democracy and human rights, and to mobilize independent civil society in these efforts. And Mr. Moderator, the representative of Azerbaijan, so-called civil society, took the liberty to refer to the ongoing democratic developments in my country. What is happening in Armenia is a democratic process, which we understand is something beyond the reach of Azerbaijan, and it is very difficult to explain to their representatives, given the fact that they are being ruled by the hereditary and repressive regime for decades. I thank you.
Thank you very much, and thank you for observing the time. And I would like, this is a good moment to remind all the delegations who would like to exercise the right of reply to sign up at the back of the head table. Now I would like to give a floor to a Commission of the Protection of the Illegally Accused, followed by All Ukrainian European Foundation, the League of Law.
Good day, ladies and gentlemen. My name is Yulia Vasilenko, and I'm head of the Commission of the Protection of the Legally Accused in Ukraine. Now, despite the reforms in Ukraine, our monitoring of situation in the courts in 2019 have shown us that there have been various violations. The standards concerning dismissal of judges don't really work. We have in fact observed that judges who are being dismissed, even before this is sent to automatic determination by the corresponding body, they already know when the dismissal will take place. And courts in which such dismissals take place, in 99% of cases, the justification for any appeal is simply ignored and the dismissal takes place. Courts are dependent on the forces of law and order. We have observed that it is very rare for there to be acceptance of open proceedings. It's always in camera. Despite this, the courts not only do not refuse carrying out illegal activities that are asked for by the forces of law and order, they are in fact accepting this. Furthermore, they support the forces of law and order in putting pressure on accused. We observed such a violation in the case of Stalmashenko in the Pridnepropetrovsky Regional Court. The individual was in pre-trial detention, and it was simply announced that the criminal proceedings have been brought to an end, and this individual could be sent to a prison colony and was not able to participate in any hearing whatsoever. And there are also there's also court shopping. There have been various cases when the investigation actually submits the proceedings to several different courts and accepts the one that agrees for an in-camera hearing and accepts the evidence submitted by the investigation arm. And then they accept the court that is most convenient. And I would draw your attention to the fact that this really is a complete violation of independence of the judiciary. Thank you for your attention.
Followed by Institute of Legal Policy and Social Protection, named in honor of Irina Berezhna.
Good afternoon, Mr. Shevchuk, the League of Rights, Lvov, Ukraine. I want to talk about political influence over the judiciary and also violations of human rights during the judicial reform in Ukraine. The judiciary is heavily politicized, and those exercising undue influence are not being held accountable. Control has been installed over the courts. Very often paramilitary units are used, and these units masquerade as civil society organizations. Those in favor of the anti-terrorist organization are in fact engaged in military activities in eastern Ukraine. Here's a case, Mr. Shestuk. The victim is Mr. Vermenko, who's part of that anti-terrorist organization supporting supposed NGO. So what was requested is that what happened is that an MP, Mr. Antonishak, exercised his influence in order to protect that supposed NGO, the ATO. The law enforcement authorities were, of course, contacted, but there was no investigation, which once again serves to show that MPs are exercising influence over the courts. What happened next is that in the spring of 2019, members of this ATO, supposed NGO, have continued to do as they please, and they disrupted the campaigning of Vladimir Zelensky in Lvov. What we need to do, therefore, is to introduce controls over the activities of paramilitary bodies and the violations that they commit. We further need to reconsider the judiciary reform which took place. For instance, the cases are not distributed amongst the judges on an automatic basis in the new appeal courses. There have been a number of cases. For instance, the Mr. Grishin case in Lvov, which attests to the violations. Basically, the reform amounted to simply changing the names of the courts. There were no other changes. When the courts were shut down and set up, the rights of a number of parties were violated, especially when it came to the distribution of cases. The courts work as per the Code of Criminal Procedure. And this Code of Criminal Procedure says that, thank you very much, I do apologize, your time is up.
Statement and recommendations to the Documentation Center. And now I would like to give the floor to Institute of Legal Policy and Social Protection, followed by NGO, Anti-Fascist Human Rights League.
I'm head of the Ukrainian Institute for Social Protection, Legal Policy and Social Protection, named in the honor of Irina Berezhina. Since 2014, our institute has been monitoring violations of human rights in Ukraine, especially when it comes to access to the judiciary. The European Court of Human Rights on 12 October 2017 has submitted to the Committee of Ministers of the Council of Europe more than 12,000 cases of sentences by courts that are not enforced at all. And it was decided to unite these 12,000 with 43 other cases that have to do with non-execution of legal decisions. It's the first time that the European Court has taken a decision of this kind, and it's never been leveled against any state other than Ukraine. And this shows that for many years, Ukraine has simply been ignoring sentences of its own national courts and of the European Court of Human Rights, and therefore depriving millions of citizens with genuine access to the judiciary. The state of Ukraine has been given 2 years to deal with all of these cases. The 2 years have almost elapsed, and according to the data of the Committee of Ministers of the Council of Europe, and the requirements have been met only in the case of less than 200 cases, and some other cases have been identified where additional measures are not required. Now, unfortunately, the HDIM and the ODIHR has not reacted at all to these actions of the state of Ukraine, and the European Union, speaking here in the name represented by Germany, has not referred to this at all, has not in its report named Ukraine at all. At the present time, the exact number of judicial sentences which have not been enforced has not been determined. Some people talk about 120,000, some about 200,000, where the sentences are not enforced and where citizens have to turn to the court in Strasbourg, the European Court of Human Rights. And then there is also the issue of social protection, non-payment of pensions. These are sentences that were handed down more than 5 years ago. Can I move to my recommendations? No, I'm sorry. You will have to submit that to the Documentation Center.
Speaker, thank you very much. Next one on the list is NGO, Anti-Fascist Human Rights League, followed by Protection of Rights Without Borders. Please.
I wanted to draw your attention to the fact that the Anti-Fascist League monitors the implementation of the rule of law and access to justice. I want to say the following. In Ukraine, democratic norms are simply a copy-paste job from similar European jobs. And this copy-paste effort does not mean that these laws, these norms, will in fact be applied, especially in criminal proceedings. I want to draw your attention to the fact that in 2014, in Ukraine, the criminal legislation was made more stringent, especially when it comes to provisions such as treason, violent overthrow of the constitutional order, violations of the territorial integrity of Ukraine, and all of these articles are now being used against journalists, bloggers, opposition figures. As a consequence, we've seen Kirill Vyshinsky, Ruslan Katsaba, Vasily Moravitsky, those journalists prosecuted, Mr. Sagan, Mr. Baradov, Kalina Vishera, Andrei Leshik, Andrei Rekhov, Oksana Karyetsky, and many other activists, journalists, bloggers, film directors have all been prosecuted. We have just one case, Mr. Volkov, a blogger and a journalist. He was acquitted after charges were brought against him, saying that he was undermining the security of the state. Also, in 2014, an amendment was made to the Code of Criminal Procedure. The situation now is that the only mode of pretrial detention is, in fact, time spent in a pretrial detention center. As a result, these people, as they were awaiting trial, were subject to abuses from the state, and we saw that roughly 650 cases are currently before the courts. All of the charges being brought under that particular article. Very often, a plea agreement is made because a person spent 3 to 4 years in pretrial detention, and very often they admit to these crimes they are committed of, being accused of, simply in order to be able to walk free at some point. What's also happened is that Ukraine has not apologized to anyone. We had 2 acquittals, Mr. Katsabi, a journalist who was acquitted, and also Mr. Volkov. We had 20 more convictions in the city of Odessa, 20 acquittals as well, but no apologies were given for the unlawful prosecution of these persons and no compensation was paid.
Documentation Center, I would like to give the floor now to Protection of Rights Without Borders, Human Rights NGO, followed by Helsinki Association Human Rights Defender.
Thank you. I will present the prospects of judicial independence in Armenian rule of law establishment. The landscape for meaningful reforms in justice institutions has dramatically changed after the events of April 2018, when the protest movement in Armenia resulted in violent revolution and in change of government. The new government demonstrated a strong political will to counter corruption and to restore justice with effective civil society cooperation. However, the lack of comprehensive approach and relevant institutional frames for the implementation remains as a main challenge for the meaningful reforms. Below, certain important dimensions for judicial independence and rule of law establishment in Armenia are presented. The judicial and legal reform strategy. In August 2019, the Ministry of Justice presented the Judicial and Legal Reform Strategy for 2019-2023. The strategy program is inclusive, presenting the approaches and recommendations made by civil society. Moreover, the Ministry of Justice has taken active steps for effective discussions with all the stakeholders. However, the reform strategy still needs improvements, particularly. The strategy encompasses several reform goals. However, the logical link between those goals and their impact in the improvement of judiciary is not well presented. The reform strategy doesn't lean on institutional amendments of judiciary, rather it targets more legislative changes. The strategy foresees overall 18 reform sectors, the majority of which has been included in previous reform programs. The broad and comprehensive list of reform sectors is welcomed. However, the practice of implementation of previous reform programs shows that not all the sectors and objectives prescribed are being implemented. The strategy doesn't target improvement of the existing mechanism and conceptual changes for selection and appointment of judges, assessment of judges and disciplinary liability procedures. Problems influencing independence of judges related to the absence of clear grounds for disciplinary liability, objective criteria of their assessment, and abuses during appointment processes have been raised for many years and led to serious concern. Second, the role of Supreme Judicial Council and selection and appointment of its members. Within judicial reform and judicial independence establishment, the functioning of Supreme Judicial Council has a central role. It should be noted, however, that the nomination and selection of its members as the main self-governing body of judiciary remains very much politicized, and authorities in power refuse to make relevant legal amendments before the selection of new members. The nomination of the candidate for the Supreme Judicial...
Thank you very much indeed. I do apologize. I have to stop you now, and please do kindly submit your very important statement to the Documentation Center. This is much appreciated. I would like to give the floor now to Helsinki Association Human Rights Defender NGO, followed by Legal Education Control NGO.
Добрый день.
Good day. For many years in a row, we have been confronted with the problem that the judiciary doesn't really fulfill its function. For many years, the judiciary in many post-Soviet countries has been used as an instrument to repress oppositionists, activists, businessmen who are not in agreement with the authorities. As colleagues have said, and this is the most important, we now have a legitimate authority. We have a will on the part of the government to introduce reforms. Unfortunately, they're coming in too slowly. We still have people in the judiciary who are in control, who take decisions, and who in the past have taken decisions that were completely illegal, completely unfair, and that had nothing to do with the law or with justice. And unfortunately, they are continuing to work in their previous positions. Yes, the system is being reworked. There is a new strategic plan for the development of the judiciary. There is more cooperation with civil society. But please, my appeal to the OSCE would be to provide support to the authorities. But this is all happening too slowly. We need this to be done more quickly. If you don't have a genuinely functioning, independent judiciary in a country, then everything else can fall apart. Because if you have a situation where any citizen can turn to the judiciary and protect his rights by appealing against anyone's actions, even those of the Prime Minister, then it's a real rule of law. And that makes sense, and that is something that we desperately need. And I would also like to indicate to colleagues from Azerbaijan, we have many problems in Azerbaijan, and we hope that there will be a real revolution there, and so that Azerbaijanis can enjoy a democratic society with a rule of law, and perhaps they could pay attention to their problems rather than ours.
NGO followed by Union of Informed Citizens.
Dear colleagues, it's my distinct honor to participate in OSCE Human Dimension Implementation Meeting 2019. Previously, I had the privilege to participate in OSCE meetings in many capacities, but this is the first time I'm honored to join as a representative of the civil society. But before touching my speech, I would like to briefly address the issues raised by Azerbaijani colleague. You know, I'm the former representative of the government, and let me say that you are not the right person to assess the level of democracy in Armenia, and you are not the right person to give lessons to our Prime Minister. I am a citizen of Republic of Armenia and civil society representatives, and I should do this. And many times, even in PACE, I said, what happened in Armenia and what was possible in Armenia, it cannot be even imagined in Azerbaijan. So, and now I will present some alarming facts in my country, and you will make your conclusions. Isn't it alarming when the office of the judge who made undesired decision has been searched in his absence when he was on vacation and later his functions were suspended? Isn't it alarming that a newly government-supported Constitutional Court judge is elected in violation of laws and, in undertaking his office, gave an oath of the Constitutional Court president, challenging the legitimacy of the acting president of the court and the whole court, basing on solid support by the new government? Isn't it alarming when Venice Commission assessed this very disturbing that this statement by the judge had been uploaded by the parliamentary majority and there might be a risk of interference with the mandates of the sitting judges? Isn't it alarming when in an interview Prime Minister was using following wording about judges, looking for their old masters, screaming and howling under the doors for them to come and take care of them? Isn't it alarming when government offers unearned incomes in the form of legal bribe to the judges of Constitutional Court in exchange of early resignment? And isn't it alarming when, after Constitutional Court decision, ruling party has decided to launch a process of depriving Constitutional Court president's power to terminate the mandate? And to conclude, Dear colleagues, the OSCE Kiev recommendations emphasize that disciplinary responsibility of judges shall not extend to the content of their rulings or verdicts, including differences in legal interpretation among courts, or the examples of judicial mistakes, or to criticism of the courts. In the light of above mentioned, I think the situation in Armenia has a contradiction with OSCE standards. Therefore, I think the international community should adequately respond to these events and closely monitor the situation in Armenia. Thank you very much.
Thank you very much, and please do submit your full statement to the Documentation Center. Now I would like to give a floor to Union of Informed Citizens, followed by Helsinki Citizens Assembly, Vanadzor.
Thank you very much, Mr. Moderator. For decades, Armenia was captured by a group of corrupt people. This capture was expressed by illegal control over de jure independent institutions, among which the most important one was probably the judiciary. For decades, the courts were fully controlled by executive branch and presidents. No court did ever make a single decision that will seriously contradict the group interests of the corrupt officials and oligarchs that had captured the state. There are many examples expressing the capture of courts, such as political prisoners and so on, but these examples have been voiced in this hall for many times, and I wouldn't like to repeat it. Following the democratic change in 2018, executive and then legislative power was formed through democratic process in Armenia. But this change, unfortunately, had not reached the judicial power so far. The executive and legislative branches of government are not responsible for decisions taken by courts, but they are responsible for implementation of justice reform and the introduction of mechanisms ensuring the institutional independence of the courts. The experience of Georgia, Ukraine, and other states shows that after democratic transition, justice reform is the hardest one. But it should be also noted that the Armenian authorities were too slow in starting the justice reform. It actually started a few months ago, while that could have been started a year ago. The need of judicial reform is critical in Armenia. The judicial system needs to be freed both from those who implemented the orders of corrupt authorities for years and from traditions that violate the independence of judiciary. This should be done in a way that no one can ever capture the judiciary in Armenia again. And it is a little surprise to me that there is a representative of former government that had captured the judiciary speak about the lack of its independence now in this hall. This is quite cynical when someone who had personal responsibility as Minister of Justice to guarantee the independence of justice that actually were under total control of the executive branch is speaking about the problems of judiciary. Thank you very much.
Thank you very much. The next on my list is Helsinki Citizens Assembly, Vanadzor. And because we're actually doing quite well with time, we have about half an hour left, I would propose that we also add 5 speakers from the reserved list. So after Helsinki Citizens Assembly, Vanadzor, the next would be Council of Europe.
Thank you, moderator. 2 seconds. I'm the head of Vanadzor, Helsinki Citizens Assembly. I want to tell you about some very interesting changes which took place in Armenia, because the former Minister of Justice, in fact, she's just taken the floor as a representative of civil society. It took her just a year to become the chairperson of an NGO which we've been criticizing for many years. In fact, they spoke to the lack of independence of the judiciary. We've had a change of government following elections to the parliament. A new government was formed. However, the judiciary remains unchanged. According to assessments issued by one of the former ombudsmen of Armenia, the judiciary is corrupt to its core. And by the way, that ombudsman, in fact, stepped down before the end of his term because the executive was trying to influence him. that report is still on the agenda. Turning now to the new government. The government must enact cardinal changes, systemic changes. Legislation needs to be amended so as to ensure the independence of the judiciary. Representatives of the previous government have been criticized for supposedly meddling in the work of the independent judiciary. Well, that's rather curious, because what everyone's very concerned about is the immunity of the judiciary. Well, we're reaping what we sow, in fact. Now, the time has come for us to do something, to change things. In light of the situation, I call on ODIHR and the international community to do everything they can to assist the Armenian authorities so that we can overcome all of the hurdles on the road to judicial independence. ODIHR issues excellence reports. You monitor the work of the judiciary. You did this back in 2009. The March 1st events, we have the UPR recommendations, Council of Europe recommendations. Therefore, we're very hopeful that we will get extensive support with the cooperation of civil society. Thank you. Thank you very much for those excellent pieces of advice.
Followed by delegation of Uzbekistan.
Ladies and gentlemen, I would like to start by citing something which has been said by Jean Monnet. Jean Monnet was one of the architects of the European Union. He said, "Nothing is possible without individuals, and nothing is durable without institutions." I think this wording is very well reflecting what we are discussing today. And I would like to proceed to citing a report of the Council of Europe Secretary General on the state of democracy, human rights and rule of law, in which he said that judiciary is not immune from the environment in which it operates. And in recent years, the creeping populism and attempts to limit political freedoms among some member states have resulted in challenges to the judicial independence. And unfortunately, as we heard today, for example, in Hungary, in Poland, this has been the case, that there have been attempts by the executive power and legislative power to enact new legislation which severely limits, for example, the powers of the high judicial councils, which are the key bodies for judicial self-administration. There have been attempts also to limit the judiciary's participation in its nominations, appointments, to give leverage to the executive bodies such as ministries of justice to influence the judicial nominations. In Hungary, for example, there was an attempt to create a whole system of administrative courts which would be run basically by the Minister of Justice. However, after intervention by international community, this law, which was already adopted but it should have started operating in the next year, this was put on hold. There have been other attempts, and I would like also to remind that in addition, when we talk about judicial independence, part of the judicial independence is also prosecutorial independence, because prosecution system is a corollary to the independence of the judiciary, and without independence of the prosecution, independence of courts cannot be very effective. And even though in many countries the prosecution systems are themselves part of the executive branch of power, however, this doesn't mean that they should be dependent on the executive. And the trend in Europe, as we can see, is towards increasing more independence also of prosecution services from the executive power and of prosecutors individually within the prosecution offices. I wish you success in your work and success in your fight for judicial independence. Thank you.
And also many thanks to our dear partners from the Council of Europe, and I strongly encourage you to submit the full statement to the Documentation Center. Now I would like to give a floor to the delegation of Uzbekistan, followed by Human Rights Movement Birdvino, Kyrgyzstan.
Mr. Moderator, dear participants, ladies and gentlemen, Uzbekistan has moved into a new phase of its development. The principle of the rule of law is a basic principle for any contemporary democratic society. When talking about the importance of rule of law, our delegation can assure you that this is something that really functions in our republic. In introducing reforms to ensure the rule of law, the people of Uzbekistan are more and more confident in the fairness of the regime, and that makes the country more and more attractive and its economy to flourish. I would like to concentrate on the most important changes that have had a significant impact on the way the judiciary works and how judicial proceedings function. First of all, the independence of the courts. The personnel policy has been strengthened, and the mechanism applied to recruit and dismiss individuals has been made very independent. Currently, judges are appointed first for 5 years and then for 10, and then given a lifelong employment or appointment to the judiciary. The main work to choose candidates is done by the Senior Judicial Council. Third, more and more electronic use in the courts in order that judges be able to have access to any other sentence that may be related to the case that they are dealing with. There is a single database of court documents. And gradually we are introducing a system of publication on the internet, online, of court hearings and court documentations. Representatives of the media are able now to take photographs and to film court hearings. That makes them more transparent. When it comes to the Code of Criminal Procedure, there are various guarantees enshrined in accordance with the law, and in this respect, for judicial practice, what's very important are the annual events of the OSCE, where the experience of judicial practice in various countries are exchanged, and that makes it possible for us to benefit from international experience.
By Republican Collegium of Advocates of Kazakhstan.
Good afternoon. Our organization, Kyrgyzstan Human Rights Defense Organization, would like to draw your attention to the plight of female human rights defenders and the fact that many of the security service staff, the prosecution officers, the judiciary have committed crimes, and their crimes have gone unpunished. Our organization has been raided, searched. In fact, our work on the rights of migrants was considered to be extremist. We haven't been able to defend our rights in the courts. All attempts to hold accountable law enforcement agencies, the courts, the National Security Service, have not borne any fruit. Therefore, today, we call on the authorities of Kyrgyzstan, to the government. We call on you to ensure that the rights of human rights defenders, female and male, are upheld. We also want to ensure that we can hold accountable law enforcement agencies and all others who have violated the rights of human rights defenders. We also call on the OSCE to pay particular attention to this issue, and we call on the OSCE and the government to consider whether we can reintroduce the OSCE center in the city of Bishkek. We want to secure the status of that branch. Otherwise, the work of ODIHR in Kyrgyzstan cannot really continue. Therefore, speaking here today, I cannot but mention Mr. Azimjan, my colleague, who is currently in penitentiary colony number 19 in detention. He is there because a court decided so. He's in poor health. All of the investigations that have been done were not done properly. Therefore, I call on all OSCE participating states to do everything within their power to ensure that he is freed and so that he can enjoy his rights.
speakers on the list, but I would like to give you, I'm sorry, 2 minutes. So I have Republican Collegium of Advocates of Kazakhstan, followed by ICLAV Armenia. With that, we will close our speakers list, and I have 10 delegations which would like to exercise the right of reply. So please, Republican Collegium, 2 minutes.
Я благодарю председателя.
Thank you very much, moderator, for giving me this opportunity and to use the reserve list. Well, as a representative of Kazakhstan civil society, I'd like to refer to a few points concerning our judiciary. There are some positive aspects to the judiciary in Kazakhstan over the last few years. We, as lawyers, are seeing that the number of acquittals is requiring, that some of the novelties being introduced are improving the situation. In particular, there is this institution of mediation courts has not only been instituted, but it is part and parcel of the general court system, the court of first instances, if you will, and that can make the protection of citizens' rights more effective. There, in the Supreme Court, there are a number of commissions operating, and the head of one of the commissions is now a lawyer, and they do review the sentences that are handed down, and that is very positive. But I would like to make some recommendations because there are still difficulties. First of all, I think that jury cases should be used more frequently. It is stated that juries will be constituted in the case of particularly serious crimes. But we believe that this should not necessarily be the case only for very serious crimes, but even for serious crimes. And work on the corresponding legislation has not yet been completed. But when decisions are taken on in a given criminal case, there can be a problem of corruption and of pressure being put on members of a jury. So there are certain safeguards need to be put in this regard. Thank you very much for your recommendations. We're very grateful to you for them.
Armenia, 2 minutes.
I would like to address the importance of respecting independence of judiciary in the context of executive's efforts in fight against corruption. I do believe that anti-corruption efforts and respect for independence of judiciary go hand in hand without any conflict or negations. However, there is a trend to meticulously misusing anti-corruption institutions and procedures originally intended to protect and preserve the rule of law to accumulate power in the hands of executive against the judiciary. This is now happening in Armenia. New regulations, though being advertised as more democratic, directed to a public interest, they disguise attacks against defiant judges. Recently, a draft vested the Corruption Prevention Commission 2 powers to influence the judiciary. The power to issue a confidential report on suspicious corrupt conduct impacting their career, and the power to initiate disciplinary proceedings for asset declaration violations. However, the same legislation weakens the pre-existing independence of commission. The current law on commission establishes a procedure of nomination of the candidates on the basis of public and competitive procedure. However, the government happily reserves the implementation of this advanced provision for a future, for now relying on direct and control appointments. The draft suggests that the first composition of the commission shall be composed of candidates nominated by government, faction, Supreme Judicial Council. This process is totally politicized. At the same time, it lowers the requirements for the members of commission. This concerns age and experience. And finally, it is of discriminatory nature because it targets only the judges, while this obligation is equal to all public servants, and it has a universal nature without any linkage to judges' professional activities. To sum up, we urge all contracted parties to condemn.
Thank you very much, and please do submit your statement to the documentation center. I think one of the principles of rule of law is fairness. Everyone who was on the speakers list and reserved speakers list had a chance to speak. And now it is my pleasure to move to the right to reply. I have 11 delegations on my list. The first one is Serbia, followed by Albania, and then Hungary.
The delegation of the Republic of Serbia would like to exercise its right of reply to the statement made by the delegate of the United States of America. The Republic of Serbia is fully committed to the process of European integration, and in many occasions the Serbian authorities made it clear that they were fully committed to having a functioning judiciary within a functioning democratic state, and were ready to tackle any outstanding issue to achieve these goals. Concerning the case of brothers Bitici, I would like to use this opportunity to reiterate the unequivocal commitment of our authorities to bringing the perpetrators of all war and other crimes to justice, including this one. We can assure you that all relevant state bodies are involved in resolving this case and prosecuting the perpetrators. We believe that such approach should be applied in relation to all crimes which took place in Kosovo and Metohija. We believe it is important to work on addressing all crimes in order to achieve justice for the victims and their families and move forward with the process of reconciliation in the region of Western Balkans. Serbia has already done a lot of this in this regard and will continue to do so in the future. Thank you.
Thank you very much. The next on my list is Albania, followed by delegation of Hungary.
Thank you, Mr. Moderator. I'd like to use the right of reply to the so-called movement for the renaissance of Northern Epirus due to the distorted picture and the disinformation presented by them in front of this audience. Moreover, HDIM cannot become a tribune to extremist organizations claiming for the territories of participating states. First, Albania attaches great importance to the rule of law, rights of minorities, and persons belong to national minorities. These include the Greek minority as well. These rights are guaranteed by the Constitution of the Republic of Albania, the new law of minorities of 2017, and the domestic legal framework. These guarantees include the rights of property and free trial. Albania's commitments are in line with international standards, including the Framework Convention of the Council of Europe and for the protection of the national minorities. Second, the property rights and rights for a free trial is a constitutional right that our citizens enjoy individually and indiscriminately, regardless of nationality, ethnicity. As a member of the Convention of Human Rights, Albania recognizes the jurisdiction of Strasbourg Court and applied its decisions. Third, Albania is determined to guarantee the constitutional order and the inviolability of its territorial integrity and the rule of law and respect of lives of our citizens. The Albanian authorities have clarified on the case. Please conclude. Okay, to conclude, I would like to say that the rule of law and independence of judiciary are among the top priorities of the Albanian in the context of our European integration agenda. We'll continue to remain committed to and pay particular attention to the human rights, minority rights, and the rule of law also during our coming OSCE chairmanship next year. Thank you.
Thank you very much. The next on my list is delegation of Hungary, followed by delegation of the United States of America.
Thank you, Mr. Moderator. In reply to the remarks today on the independence of judiciary in Hungary, it should be stressed that one of the most important guarantees of judicial independence is the independence of the acting judges. Therefore, it is provided by Article 26 of the Fundamental Law of Hungary. Beyond this, judicial independence means not only the independence of judges, but the independence of the whole judiciary system as well. The framework for the judiciary in Hungary, adopted in 2011, has been carefully examined by the Venice Commission and the European Commission. These bodies have evaluated the overall arrangement as positive, and some specific elements that were pointed out have been carefully addressed by the Hungarian government. The assessment by the former Minister of Justice in Hungary was to take off the decision on administrative court from the political agenda. As a guarantee of organizational autonomy and all powers of administration of courts belong to the judicial organization, and the external administration outside cease to establish a new relationship between the court and the government. Multi-level administrative judiciary, which is institutionally independent from ordinary courts and from the jurisdiction of the Supreme Courts, operates in several EU member states,
international example proved that it ensured better the self-restraint of executive power and power that provides more efficient control over action of the administration. Thank you.
Thank you very much. Delegation of the United States, Ambassador.
First, I wish to thank the right of reply as expressed by Serbia. The United States exercises its right of reply to address some of the disrespectful misrepresentations put forward in the statement of the Russian Federation. It's simply not true that there is no oversight of prison conditions in the United States. The United States Constitution guarantees all prisoners the right to be housed in safe conditions and to not be subjected to violence and abuse. The Special Litigation Section of the Federal Department of Justice Civil Division works to protect those rights. If it finds prisoners' rights are being abused in state and local prisons, it can and does act. In fact, it was precisely this oversight that resulted in the recent report by the Department of Justice on certain Alabama prisons. In addition, our laws allow civil claims to be made against officials for violation of prisoners' constitutional rights, and our free and independent media can do report on such violations. Our independent bar further ensures that those who seek redress may pursue their claims in court. Thank you.
Thank you, Ambassador. The next on the list is delegation of Greece, followed by delegation of Poland.
Thank you, Mr. Moderator. First of all, allow me to remind that an esteemed NGO member continues to inaccurately use a wrong term when referring to the Muslim minority in Thrace. Furthermore, the Greek government has been considering appropriate ways and means of implementing 3 judgments of the European Court of Human Rights, including legislative amendments in order to make possible the reopening of the relevant domestic procedures. In this respect, in October 2017, Parliament adopted a legislative provision which allows the reopening of non-contentious judicial procedures following a judgment of the European Court of Human Rights. It is to be noted that the final decision on the registration of association lies with the competent courts and not with the administrative authorities. It is also noteworthy that the European Court had previously dismissed all 3 new cases brought before it by the aforementioned 3 minority associations based on alleged new violations of the freedom of association, finding that Greece had not committed such further violations. Thank you.
Thank you very much. The next is delegation of Poland, followed by delegation of Tajikistan.
Thank you, Mr. Moderator, and I'd like to use my right of reply with regard to remarks that have been made concerning Poland, and I would like to assure all speakers that the recommendations will be forwarded to the relevant institutions. And here I'd just like to say that the separation of powers is guaranteed by the Constitution, and the independence of judiciary remains a precondition for good functioning of the justice system. And we are in dialogue on these issues with the European Commission, and some recommendations, for example, concerning the retirement age of the judges have already been implemented, and the Polish model includes a role of the legislative power in the process of appointing judges, and thus follows the model of some EU states. Thank you.
Thank you, Poland. The next on my list is delegation of Tajikistan, followed by delegation of Armenia.
Thank you. Once again, we'd like to express our concerns regarding the participation of representatives of extremist and terrorist organizations. We also want to say the following. It's blatant lies, the fact that all MPs and judges are appointed. All MPs in the lower chamber are appointed by the people, and it's only a portion of the upper chamber that's appointed by the president. The judges are appointed on the basis of merit by the president. As for criminal cases, which are then tried behind closed doors, well, there are rules that apply to that, and there are very few cases that fall into that category. Furthermore, we are upholding our legislation and international norms to the letter. We also have some acquittals. Turning to the proceedings brought against the Islamic Renaissance Party, there is evidence that members of this organization were trying to overthrow the government using force. Also, they committed other crimes. The only people who were charged are the people who committed specific crimes. Furthermore, the Supreme Court has handed down a judgment on this case. Thank you very much.
So, delegation of Armenia, followed by Finland on behalf of the European Union.
Thank you, Mr. Moderator. My delegation would like to address the remarks concerning the judiciary system of Armenia. We heard different views and assessments coming from the Armenian representatives of the civil society. Indeed, this is a complex issue, and I'm delighted that this issue was also raised by the distinguished former Minister of Justice of Armenia, who has an in-depth knowledge and understanding of deficiencies of judiciary system, which the new government of Armenia is trying to address. The government formed after the revolution proclaimed the rehabilitation of judicial system and the fight against corruption as its priority, due to the fact that over 2 decades the deficit of justice, lack of trust, as well as the level of corruption were the key factors for the upheaval and the justified demand for the changes in Armenia by the people in spring of 2018. And finally, I would like to particularly emphasize the strong will of the current government of Armenia in attaining genuinely independent and impartial judiciary system. I thank you.
Thank you very much, Armenia. Now the delegation of Finland on behalf of the European Union, followed by delegation of Ukraine.
Thank you, Mr. Chairperson. I pass the floor to the representative of the European Union.
Thank you, Mr. Moderator. In reply to the intervention questioning the EU sanctions policy, we recall our unwavering support to the sovereignty, territorial integrity, unity, and independence of Ukraine within its international recognized borders, and we remain committed to full implementation of our non-recognition policy, including through restrictive measures. Since March 2014, the EU has progressively imposed restrictive measures against Russia. The measures were adopted in response to the illegal annexation of Crimea and the deliberate destabilization of Ukraine. We take again issue with the intolerant statement that was made during the session today by Saluye Misericorde. To those who are calling here for unequal treatment and discrimination, we say that the Universal Declaration on Human Rights is clear and that all human beings are born free and equal in dignity and rights. As we are also asked why we did not address certain country situations, we reiterate our position as stated in the statement delivered by Germany on behalf of the EU in today's session, that all participating states should preserve judicial independence and counter any attempts to limit the ability of courts and judges to perform their duties free of influence or control by other actors. Thank you.
Thank you very much. The next on my list is delegation of Ukraine, and the last right to reply will be exercised by delegation of Azerbaijan.
Thank you very much, Moderator. I would like to react to 3 points that have been made by speakers. First of all, violation of human rights in the occupied territories. I would like to draw the attention of participants once again that this is due to the aggression by the Russian Federation and the support given by the Russian Federation to the illegal armed groups in that area. When it comes to judicial reform, we initially had more than 9,000 courts, and it's really impossible to deploy large-scale reform from one day to the next, and that is why it is taking some time for the reform to be decided on and to be implemented. The Supreme Court, the Anti-Corruption Court, they have already been appointed on the basis of the new rules. Similarly, for the appeal courts, some 30% only of the previous judges are in place. When it comes to the courts of the first instance, it will obviously take some further time for the democratic procedures to be fully implemented for the appointment of the individuals. Insofar as the non-implementation of court sentences is concerned, that's the fault of the executive and not of the judiciary. Thank you.
It is not surprising that the delegation of Armenia, in its statement as a reply to the NGO from Azerbaijan, used the opportunity to attack my government. The president of Azerbaijan was elected by the will of Azerbaijani people lawfully in accordance with the constitution of Azerbaijan. And Armenia is the last country actually to lecture on rule of law since it has been using aggressive occupational policy against Azerbaijan for more than 25 years. Armenia occupied the Nagorno-Karabakh and 7 adjacent regions and carried out ethnic cleansing. and the relevant 4 resolutions of the UN Security Council demanding unconditional withdrawal of Armenian armed forces from the territory of Azerbaijan have not been fulfilled by today by Armenia. Thank you, Mr. Moderator.
Thank you very much. This is the end of the rights to reply. And as we started 10:07, I think it's just fair to give our introducer a final word for some very brief closing remarks. Madam Public Defender, the floor is yours.
Thank you very much. Very briefly, my conclusion is that, of course, each country has its own human rights challenges, and human rights issues vary country by country, but there was one issue that was mentioned by all speakers, especially represented from the representatives of civil society organizations. This is alarming trend of interference in judicial independence, which is expressed in many different forms, such as verbal attacks on judges, government-backed discreditation campaign against independent judges, using disciplinary procedures against independent judges, interference in appointment process, and etc. Alarming is the fact that independence of judiciary is deteriorating, and it is happening in some European Union member states as well. It is especially unfortunate because EU countries, EU member states, represent exemplary countries for non-EU member and former Soviet Union countries. And therefore, those negative trends and processes in those countries will definitely have chilling effect on judicial independence in other countries as well. So my recommendations would be that, and my first suggestion would to the human rights defenders, national human rights institutions, civil society organizations, international communities, international human rights organizations would be to prioritize judicial independence issues in their activities. My recommendations to civil society organizations and human rights defenders would be to, when dealing with the problems of independence of judiciary, pay attention to the systemic structural problems in the justice system, not only do not pay attention only to the individual cases, but deal with the problem as a systemic issue. Also, early intervention when something is happening is very crucial. Intervene and raise alarm as soon as possible as there is first signs of non-democratic processes. Do your best, make public statement, monitor the process, request the attention from international community, request the assistance from international organizations. And also, I would like to highlight the importance of cooperation between domestic and international stakeholders, civil society organizations, human rights defenders, international human rights organizations on this matter. And I would like to once again encourage you to strengthen your cooperation with OSCE ODIHR and to request respective opinions on draft laws or submission of amicus briefs, request to deploy the monitoring mission in your country when you consider that the engagement of international organization is necessary. Finally, I think that on the other hand, it will allow OSCE to have better understanding and knowledge of the situation in its member states and to identify problematic global trends and therefore prioritize and strengthen your activities in this direction. Thank you very much.
Thank you very much indeed, Madam Public Defender. Excellent closing remarks. I would like to first of all thank you, thank all the speakers, thank all the delegations, and our wonderful interpreters. Thank you very much indeed for staying those extra few minutes. You know all about how to register for the next session, and you know that you need to leave your hand resets. So I will move immediately to invite you to the very important side event. We invite you to the side event, the long path to recognition of the Roma and Sinti Holocaust, displayed in the hallway nearby the elevators for the entire week of HDIM. This is a special exhibition which will be with us for this week. Thank you very much indeed for your active participation, and the session is over. Thank you.